May I please, my lord? I am for the appellant, my lord. Now, in this case, my lord, my lord, there is provision in the Orissa Education Act that in case of a termination of a teacher, in case of termination of a teacher in an elders college or school, then that terminated employee shall approach the State Education Tribunal under Section 10A of the Orissa Education Act 1969. But here in this instant case, the respondent number 3 petitioner, without approaching the London State Education Tribunal under Section 10A of the Orissa Education Act 1969, has approached this Honorable Court in the form of writ petition and has obtained order, and I challenge this order. Your
On
Lordship,
that ground.
my lord,
On that ground.
my lord. Other grounds are there. Main ground is that my humble submission is that
That ground is rejected. Come to the other ground.
other ground is that the petitioner was engaged as a just guest lecturer, and the provision, your lordship, kindly have a glance at the page 31. May I submit, my
Yes, my lord is pointing out
my
to paragraph 9 of the impugn order. Whether that is correct or not. That is correct.
9.
Page 45.
Yes, but
Right. No, it is yes, 9. 9, it has been mentioned, and another order is there also, previous order, and it has been said that this order post effective, that there is a prior effective. I am just showing the
What happened? Whether you have challenged that in writ appeal?
I have
Very same order
My lord.
was the subject matter of another writ petition.
yes.
my lord.
That is the case of Soumya
Soumya
Sridhar.
Das.
Okay,
In that same case,
That is
in the
implemented.
same case also,
please listen to us.
my
So that order was also quashed and
lord,
that has already been implemented. You have not challenged.
that has not been
Now,
done.
how can you challenge now?
My lord, the
So on the ground of parity,
My-
one particular order has been passed
My lord.
in respect of one person. The same thing applies to that one. That is the observation.
My humble submission in this respect is that if any illegality has been committed, then that and violating the statutory provisions of appeal, then the same illegality may not be.
On a particular ground,
Mr. Counsel, you are challenging the order also on the ground
Well.
that the writ court directly entertained the petition.
My
So we have rejected that point.
lord.
Now, do you have any other point in the background of what has been held in paragraph 9?
My lord.
What?
The provision I'm showing just. I'll kindly have a glance page 31.
So paragraph 9 is incorrect.
No, it
What
is
hap-
not. It is not correct. I will come. This is the consequence. Paragraph 9 is the consequence, and prior is that my humble submission is that once the college comes into the granting aid, the college authority governing body has no power to appoint a person, and that has been described in page
Yes.
31.
Tell us the facts of your case.
My lord, But I'm saying,
Please tell us the facts of your case.
fact is case that the petitioner was appointed as a guest lecturer. Was
Petitioner small number?
3.
Yes.
Respondent number 3.
Yes.
Petitioner was appointed was engaged in the college as a guest lecturer in the year 2009, and to that effect, the grant appointment letter was issued. And again, the advertisement was issued in the year 2013. And again, while continuing, she says, while continuing as the guest lecturer since 2019, she
2009.
again, my lord, again, she also faced the interview in the 2013. Again, another appointment order was also issued. 2 appointment orders are there. And she says that
2 appointment letters, second appointment letter was issued against which post? Again, guest lecturer.
yes, not guest lecturer was not mentioned, but appointed as a lecturer was mentioned.
So regular lecturer she was appointed, or he was appointed.
My humble submission is that the college cannot appoint as a regular lecturer. This is the letter I am showing 31. Once the college has comes into the granting therefore, the governing body has no authority to appoint a lecturer, but it is the state through SSB, that is State Selection Board, that shall be appointed. And that is the, see, my lordship, kindly bear with 1 minute. I am showing what is the position in 1998.
You are becoming impatient. We are not becoming impatient.
I am one of the.
Just bear with me. 1 minute means we interfered with you. Then why are you saying?
I may pardon for this. I would do this. But my humble submission is that it's in 1998. The stipulation has been made. The state government has issued order that no appointment shall be made, and this provision should be strictly followed.
Had you also applied against the advertisement?
I am the governing body, my lord.
You are the governing body.
My lord.
So the advertisement was issued by whom?
Advertisement was issued by the governing body.
So you are challenging the governing body, challenging the decision of the governing body.
But the position is that the state's selection board should have appointed. But when the situation vacates,
Sir, let us understand.
My lord.
You are the governing body.
My lord.
Governing body had issued advertisement in 2013. You are challenging the decision of the governing body.
My lord, not that to meet the exigency, emergency situation. When the situation, then what happens?
We are unable to understand. Please make it clear.
My lord.
That the governing body, according to you, had issued an advertisement in 2013.
In pursuance to the order passed by the state government. The order state government that we are at present, we are unable to provide you the lecturers. So if to meet the urgent situation, you please appoint or engage some guest lecturers. This is the order, this is the letter, my lord. Yeah, let's kind page 31, I am showing. Page 31. May I permitted to read?
So are we clear,
my lord,
that you are governing body of a college?
My lord.
And the same governing body had issued an advertisement in 2013.
My lord.
And based on that, the governing body had made certain appointments.
My lord.
According to you, those appointments were bad.
Even those advertisements are bad in view of the state government.
You are challenging your own action.
My lord, I am constrained.
So yes.
My
so
lord.
You are challenging your own action.
My lord. But what happens here, my lord?
Yes.
In different times, different principals come. So one principal does something against the rules and provisions provided by the state government. The state government totally forbids to make any appointment. But here, during different times, the governing body or the principal secretary has. But my humble submission is that no, those 2 appointment orders of the respondent has not been supported by any governing body resolution. No resolution has been held. You'll also kindly have page 31.
So which order was under challenge before the writ court?
Judgment, my lord, your lordship kindly have a
Which
glance.
order was challenged before the writ court?
Read court is that order of termination.
Which day?
Termination
Which day?
is Annexure 5 at page 24.
That is the date. That is the date.
Sorry. It's 4/5/2017.
4/5/2017.
Mile.
Now come to paragraph 9.
Paragraph 9. Mile. Mile.
Yes.
Place that paragraph, please.
Mile. A bare reading of the impugned order dated 4th May 2017.
Same order. 4 May 2017. Yes.
Fourth May. Office order dated 4/5/2017 in obedience to the
Same order was under challenge.
Mile.
Who is shouting?
From judgment paragraph 9, I couldn't follow.
Please place the judgment in paragraph 9.
9.
And my lord is asking you a pertinent question. This order dated 4th May 2017
Mile.
was also the subject matter of challenge in another writ petition.
Yes.
That is in respect of Soumya Sri Das.
Mile.
And the very same ground on which that order was quashed is also applicable to this case. And that particular order you have not challenged, that has already been implemented.
My lord, this is a fact.
This is the fact.
Mile.
Then you will have to pay some cost.
Well, I cannot, as a counsel, I cannot improve.
You cannot. Right.
But the position is that this governing body has no power to appoint those persons, my lord. Those persons are the in case of what I have got instruction.
So why did you not challenge that order?
But the principals are different, the governing bodies are different. What can be done?
We refrain from using appropriate expression. You understand? We would have used that. The governing body changes because of a person, because of change of a person.
My humble submission that the governing body has.
The body is continuous.
Body is continuous, my lord, but the governing body has not given any.
Then why did you not challenge that order?
It has not been challenged. I can.
You are discriminating between the employees of your institution.
My purpose is to satisfy my lord, convince your my lord, that the illegality committed in one order cannot be allowed to continue here. My entire endeavor is here.
All right. In the present intra-court appeal, the appellant, governing body, Viren Mitra Memorial Women's College, Thoria Sahi, has put to challenge an order passed by a learned single judge of this court dated 11/8/2022 in WPC number 9746 of 2017. Full stop. From their perusal of the order of learned single judge, which is under challenge in the present appeal, it is apparent that that an order dated 4/5/2017 was subject matter of challenge in WPC. What is the number of the earlier case? Earlier.
Case number of that lady that
8396 of 17. This is the order.
Soumya Sridhar.
Yes.
83
WPC 8396 of 2017. This is the order.
2000. Okay, that is.
Subject matter of challenge in WPC number 8396 of 2017, which came to be disposed of by an order dated 12/5/2020. Stop. It is noteworthy, it is not in dispute that in the light of party का नाम लिख देना, Soumya Sridhar versus governing body. It is not in dispute that governing body, that the appellant was a party in the said WPC number 8396 of 2017. Stop. It is also not in dispute that pursuant to the decision of the learned single judge dated 12/5/2020 in WPC number 8396 of 2017, the governing body has implemented the order. Implemented the order. Stop. Following the decision rendered in case of Soumya Sridhar, learned single judge disposed of learned single judge by an order which is under challenge in the present appeal, passed the following order, paragraphs 9 and 10. Stop. Next, assailing the impugned order of the learned single judge, learned counsel representing the appellant, that is governing body of Biren Mitra Memorial Women's College and others, has submitted that the writ petition was wrongly entertained by the learned single judge, there being statutory remedy available to the writ petitioner / opposite party number 1.
Respond number 3 here.
Respond
Now
three,
here.
three, four.
Respond number 3.
Respond three.
Respond 3.
Respond number 3. Under which provision is that?
Under section 10A3.
Under section 10A3
Section 10A3.
of
3 of Odisha Education Act 1969.
of the Odisha Education Act, 1969.
Mine.
Stop. We reject this submission at the threshold. Stop. it is a settled legal position that availability of an alternative remedy does not bar exercise of writ jurisdiction under Article 226 of the Constitution of India. Full stop. He has also argued that the decision in case of Soumya Sri Das bracketed Supra suffers from illegality. Full stop. The governing body of Biren Mitra Memorial Women's College, after having accepted the said decision rendered in case of Soumya Sri Das, cannot question the legality thereof in the present appeal. So stop. This appeal, the filing of the intra-court appeal is taking into account the fact that the governing body implemented the order of this court, which dealt with of this court in case of Soumya Sri Das, which dealt with the same order dated 4/5/2017, which was subject matter of challenge in WP number so and so, comma, in the background of the facts noted above, this appeal cannot be entertained. This appeal deserves to be dismissed with costs. Stop. The appeal is accordingly dismissed with a cost of rupees 20,000 to be paid by the appellant to be, yes, to, who is for the respondent number 3? You are. To be paid to the respondent number 3 within 2 months.
May I pray one line from the one judgment petition? One line, I'm just citing. An illegality cannot be regularized, particularly when the statute in no unmistakable term says so. This is the Mamata Ma decision, Supreme Court decision. Let's see,
Submission, man. It's illegal. And the order is illegal. That order is illegal. And be perpetuated.
Man.
That's all.
Another ground is. Shut up! Pardon.
Yes.
Item number 2.
Supplementary affidavit, my lords, I was just checking up that supplementary affidavit needs to be filed in terms of the format. This was filed earlier to the amendment. Can I only pray for some time, your lordship?
Which case?
Item 2, my lords.
What do you want?
I want to file a supplementary affidavit in terms of the High Court format. Whatever time, your lordship.
How much time?
Whatever time your lordship grants, my lords.
2 weeks.
Grateful. Great.
Item number 3.
I'm sorry to say that it is perhaps it is a single bench matter, though it is a matter of contract, but I am challenging in this writ application the order of the forum which has been constituted under the contract. I draw your honor's attention.
Now, why the matter has been placed before DB?
Madam, that was listed before the single judge. I filed a single copy that was listed for the single judge.
Yes.
But on that date, I was absent. I have instructed one of my friend to take 2 days time, but that has not been made, and the honorable single judge directed, since it is a contract matter, perhaps it will be listed before the division bench. That, and with that observation, restamping was there, assessment was there, and that has been division bench had made. But that is, the fact is that I am challenging in this application, the order of the forum, which is constituted under the contract provisions. Your lordship have look to page 19. Page 19 of the.
Page 19.
Yes, Mela. Page 19 of the writ application.
Yes.
This is the dispute redressal system. It is a contract. When there is a dispute that can be settled by the under clause 24, that is dispute redressal system. Got it, Mela?
Yes.
It is 24(1). That the engineering committee is there to empower to constitute the result.
No, what do you want? What is your prayer?
No, my prayer, I am challenging the order of the forum. That is under on Annexure 696/2023. That was under challenge.
That was under challenge.
Mela?
What do you want to say? What do you mean that was under challenge? What is your prayer?
My respectful submission that whether that will be single bench or division bench, if a lordship should take the matter.
In view of the order of the land and single judge, the matter was examined by the registry.
Yes.
The registry has placed a note that it is a division bench matter.
Yes, if that will be, I have no.
We will hear.
Yes, ma'am. All right.
Irrespective of the
But
fact.
I am sorry that I have not filed the division, the second copy. I may permitted to file this.
You can file it.
Second copy is there.
Yes, madam.
Your affidavit is proper.
Then I am placing the case, madam. And I am placing this case.
Is your affidavit in order?
Let it next week. I'll
1 week. Additional affidavit.
Item number 4.
Item number 4, my lord. In compliance to my lord's order, my learned friend has sought copy of writ petition on May, my lord. I have received copy. Your lordship grant 5 weeks time so that I can file my counter.
How much time?
3 weeks time, my lord.
I pray, my lord, I can file the supplementary affidavit because I have not filed it.
Okay. 3 weeks time is allowed for the respondents to file their counter affidavit. Opposite parties.
Opposite partner 1, my lord.
Opposite party
The sole
is going to file its counter affidavit. Stop. And counsel for the petitioner shall also be required to file an additional affidavit supporting the averments made in the writ petition in accordance with terms.
May I? Pardon? The item 3, 2 weeks with the supplementary affidavit within 2 weeks.
2 weeks.
Item number 5.
The opposition number 5, the Sarpanch of the Aurangabad Panchayat, Lordship, without recommendation and signature of the Police Sabha members and ward members, approve the all Panchayat wards
This is
and
PIL.
your Lordships. And my representation is also pending. Annexure 1, 13 your Lords, page 13. Before the collector and BDO since 12/5/2023. All the projects works are continuing, which are not satisfactory and less quality and where the Sarpanch and his husband attending to
This PIL is malicious.
all the village, some of the village people and one of
Come
the
to the
petition.
clear portion. Stop defective project works.
Yes,
How do you say that the work is defective?
defective your Lordships, the two villages are declared as the ideal village in that is the Rajpur and Phulpur, the two villages where the government sanctioned 1 crore 35 lakhs. And 80 lakhs already are sanctioned and the two projects are continuing in two villages, your Lordship. That the works is in the not satisfactory, your Lordships. And
How?
all the village peoples, including the ward members and village police sabha members.
What is the standard of their satisfaction? How could they realize that the work is not satisfactory?
Without the recommendation and signature of the police sabha members and the ward members, the Sarpanch can do everything, Your Lordship.
No, you are just telling that the work is not satisfactory. How did you assess that work, that it is not up to the standard which is required? Are you an expert in this line, civil engineering? The petitioner is an expert.
No, Your
How
Lordship,
did you-
the
no.
village people are observing, and they are the objected, Your Lordship, the work is not properly.
So is there some dispute between you and Sarpanch?
So, not some village people and including the present petitions who had made a representations before the collector and the Sarpanch, video, Your Lordship.
The petitioner, in the present application in writ petition in the nature of public interest litigation alleges that the works which are continuing in Aurangabad Panchayat under PMAGY scheme works is not satisfactory. Full stop. Accordingly, a direction is being sought to the opposite parties number 2 and 3 to take necessary steps to stop the defective project. Stop defective project works. Full stop. A direction is also being sought to cause an inquiry into the irregularities committed by the Sarpanch of Sarpanch bracketed opposite party number 5 of the said Panchayat. Full stop. Next. The petitioner has miserably failed to demonstrate, based on any objective failed to demonstrate failed to satisfy this court as to what was the basis for the petitioner to assess that the work in question is defective. So stop. This public interest litigation, in our opinion, lacks bona fide. So stop. Lacks bona fide and is accordingly dismissed. So stop. Next, we make it clear that any observation made in the present order shall not be construed as the court's opinion on the quality of work which is being done. So stop. A competent authority shall be free to look into the matter and ensure that the quality of work is being maintained. Yes.
Item number 6.
May I please, Your Lordship? My Lord, we'll bring the supplementary affidavit on record by tomorrow, my Lord. May this matter taken up next week?
We are the matter will come on in the next week. In the meanwhile, you may do it.
Lordship,
The union opinion,
May I
pupil
wait
number
for
3,
next week, my
let
Lord?
them serve the copy, let them serve the copy.
We'll serve a copy, my Lord. May it take on next week?
Just a moment. Let a copy of the writ petition be served on learned by tomorrow. So stop. Then counsel for the petitioner, shall also be required to file an additional affidavit supporting the averments made in the writ petition in accordance with so and so. List this case on next Tuesday.
Deeply obliged, my lord.
Item number 7.
My lord, the opposite party number 7, who is the hardened criminal having 20 numbers of criminal antecedents, is doing unauthorized and illegal liquor business near the school and in the village and the Anganwadi center and near the temple, my lord. For which the petitioners who are the villagers have made representation to the authorities which is pending at the Annexure 1, my lord. That may be directed to dispose the reprehension under Annexure 1. Annexure 1 series. That is to Excise Commissioner, Excise Inspector,
When
Collector.
was the representation made?
My lord, at 10/7/2023, my lord.
You have not given the copy of the Annexure 2.
My lord.
And where is the receipt?
My lord, receipt is page 21, my lord. Postal receipt.
In the present writ application, in the nature of public interest litigation, the petitioners who are villagers of Rahan village under the district of Jagat Singhpur asserts, how many petitioners are there?
My lord, 6 petitions.
Petitioners assert that who is running?
My lord, opposite party number 7 and his wife, my lord. Opposite party 8. 7 and 8.
That opposite parties number. You have mentioned 6 to 8.
My lord, 1 to 6 are government authorities, my lord. Opposite party.
Paragraph 4.3. That opposite party number 6 to 8 who are residents of the same village are
Government officer.
who are residents of the same village are running unauthorized liquor business. No, they have no licenses.
No license, my lord.
Then you could have one could have filed a criminal case. Criminal cases.
My lord, criminal case is pending, my lord.
Petition, you could have filed a criminal case.
My lord, 20 criminal cases are pending, my lord.
You have given
And
10.
4.6, I have collected only 11.
You have given 10 numbers.
Or
against
10 numbers, but
File your affidavit. 4 weeks time is allowed for the estate to file counter affidavit. Let's discuss 4 weeks.
Item number 8.
problem.
May I please, Lordship? But in this matter, this work in question has two parts, Lordship. First, construction of work, then maintenance, Lordship. I have already completed the works, and Lordship, now the maintenance part is under progress. And Lordship, while this was the position, they have issued Annexure 5 at running page 156, Lordship, page Annexure 5. Taking into the inquiry report of National Quality Monitor, Lordship, the system, the mechanism. Now they are saying you complete the ongoing works, which has been left out during construction, Lordship, of the work. So, Lordship, the guideline itself speaks, Lordship, within 1.5 year, Lordship, they will use to come for an inspection. If there is some liability, then I will maintain it. But now the present, Lordship, the situation, Lordship, kindly see status come to Annexure 8, Lordship. Now the same work in question has been put to tender by the department, and they have allotted a work to some person of cost of more than 6 crores, Lordship. So they will work accordingly. And now the question of maintenance or repairing does not arise because the said road.
Where is the contract? There is no arbitration clause, something.
No, Lordship, Lordship, in fact, I am not on arbitration, Lordship. But I have completed the work. The work in question, Lordship, in two parts. First, I have to complete the work, then I will maintain it, Lordship. Maintenance for 5 years. In maintenance for after 2 years, they have come up with an allegation, Lordship. I have left out some work so far the ongoing work is concerned. So that is not possible now, Lordship, to trace out whether I have completed not after 2 years. But my humble submission for Lordship, now the self-same road, they have been handed over to another agency for construction again by allotting more than 6 crores.
So you want that instead of asking you to construct the leftover work,
Lordship,
a criminal case ought to have been instituted against you.
In fact, Lordship, kindly come to Lordship.
You may be right in your submission.
No, in fact, that is not submission.
Yes.
My submission, Lordship.
The fact is
Lordship,
that according to you, you had completed the work.
Lordship.
The work was complete and maintenance part was pending.
Continuing, Lordship.
Continuing,
Lordship.
Still continuing.
Lordship.
Now, in the meanwhile, they noticed that part of the work for which you had already
Completed.
you were paid, and according to you, it was completed, was in fact not completed.
No, in fact, Lordship, my humble submission that there is a period within 1.5 hours. No, they have every right to inspect.
Yes. All right. But that doesn't bar institution of a criminal case.
No, Lordship, my humble submission.
Yes.
Miller's ongoing construction of work, Lordship,
We
already
understand
complete.
everything. Mr. Counsel, we understand everything.
Already completed, Lordship.
Yes,
Had it been a case, Lordship, during that period, it could have been tested out, Lordship, or could have been, Lordship.
Just think of a circumstance that when you are asked to construct a bridge,
Lordship,
and you construct the bridge,
Lordship,
and you receive the payment.
Lordship.
But after the period of contract, it is noticed that in fact there was no bridge constructed.
Lordship.
Ever.
Lordship, I Lordship quite agree with Lordship.
I agree with
but here is not that case, Lordship. Here, Lordship, there are two mechanisms. One is from state, another is from central. During my construction, Lordship, state inquired the matter and pointed out some liability. I repaired, Lordship. And that part already been completed.
You can file a suit, whatever.
No, I'm not on suit, Lordship. Lordship, state come to Annexure 8 for a moment.
Annexure 8.
8, Lordship. That is running page, Lordship, 205.
Yes.
Lordship, now it is dated 8/9/2023.
Yes.
Lordship, status come to serial number 18.
Yes.
At the same road, Lordship, and serial page 206, improvements such as widening and strengthening of Padalguda.
This we understand, Mr.
Lordship.
This we understand. Now fresh tenders have been invited.
Lordship.
For the same
work of 36 crores, Lordship.
All right.
So, Lordship, maintenance also not now possible because they have taken up a new construction. So, question of maintenance does not arise, Lordship. Right. So, Lordship, at this stage, Lordship, my humble submission, this letter itself under Annexure 5 has no meaning. That is my submission.
We are directing them to lodge, to conduct an inquiry.
Lordship, that and my humble submission, Lordship, the state agents have already inquired in the matter and given report in favor of me. And the subsequent report, the relying upon me, they issue notice me.
Because they were party to your construction. They must have supervised the,
Yes,
the
They've
construction.
already given report in favor of me, Lordship.
No, that inquiry report is not in your favor.
Has to
That inquiry report is in their own favor.
Lordship, that is, Lordship, in fact, Lordship, there are two reports. I am relaying one report of the state agency during ongoing works, Lordship.
Yeah.
That was inquired into, and I have completed the work, Lordship. Then now, Lordship,
We will-
after belated stage,
All right, all right. Every aspect has been gone into. File your affidavit, we will see.
Lordship.
So kindly see for a moment of that impugned order itself. I want
File your
to,
affidavit.
I'll file.
File your affidavit. If your officers have done
No,
this, then
no,
they'll
no.
have to be prosecuted.
Lordship, kindly see page 156 for a moment. The impugned order. The impugned letter, my lord. 156, annexure 5.
Yes.
I am reading that, my lord. Regarding subject, regarding non-compliance of NQM. NQM is a National Quality Monitor, my lord. ATM for package number OR 22230, Rodalgunda to Tonda Road. Sir, with reference to the subject cited above, you are instructed to carry out the rectification work to the deficiency found by NQM for PMGSY road package number such and such during his inspection on dated 23/4/2023. But you have not carried out the rectification work to the deficiencies after several reminders, which is a fundamental breach of the contract. However, you are once again instructed to carry out the rectification work to the deficiencies observed by NQM. If you fail to start the rectification work within 7 days of issue of this letter, the same shall be executed by other contractor, and the payment towards the work will be made of your ongoing work bills, security deposit, performance security deposit available within the division, or it will be recovered from any dues payable to you from state PMGSY works, any other state government works, including state public sector works executed by you. If any amount will still remains unrecovered, it shall be recovered as area of land revenue as per GCC clause 53.2, my lord. This is for your information. And Lord,
Madam State Council,
my lord,
suppose he has done a particular piece of work
my lord,
and some works he has not done.
my lord.
Now, since you have already invited tender, the new person will complete the entire thing. So whatever he has done, why don't you pay for that? Why are you asking him to do the incomplete work since you have already?
No, my lord, Lordship kindly see his reply. The next page, my lord, what is his reply? We have written a letter on 4/1/2024. Lordship kindly see 6/2/2024 his reply, because he has to maintain that road. Lordship kindly see what is his reply, the last two paragraph, my lord. In this road, seal coat and surface deserving were done as per the estimate.
Which page?
Lordship page 157, next
Yes.
page, my lord.
Yes, yes,
Last two paragraph, my lord.
yes.
In this road, seal coat and surface dressing were drawn as per the estimate, due to heavy traffic, not able to maintain it throughout the years for a long time, but we are maintained properly.
Which paragraph?
Last two paragraphs, my lord. In this road,
157.
seal coat and surface dressing were done as per the estimate, due to heavy traffic, not able to maintain it throughout the years for a long time, but we are maintained properly. But this is his responsibility, my lord, to maintain for 5 years after completion of the road, my lord. He is not doing that. Lordship kindly see.
And where is the arbitration clause?
And Lordship kindly see page 54, my lord, for a moment. The detention clause, my lord. Page 54, my lord.
What is that clause?
Detention clause of the tender notice, my lord.
No, where is the arbitration clause? See, this,
No, arbitration clause, my lord.
it is very difficult for the writ court to go into
My
such
lord, my lord.
disputes
My
and decide.
lord.
May require evidence, they may require inquiry.
But my humble summary, Lordship, I have completed the work. I am maintaining it, Lordship.
Sir, can we give you a certificate?
No, I'm not on the Lordship. Already they have handed the same work to other agency. For construction. So question of maintenance.
Counsel, your dispute arises out of an agreement.
Lordship.
So we want to know where is the dispute redressal
Redressal for
clause
lordship.
under the agreement.
That is there, Lordship.
That is there, then invoke that.
But rightly, Lordship.
They have not submitted the agreement.
Affidavit, Lordship, it
No, why?
But agreement is not submitted.
will agreement, the enter condition I have.
What is this, annexure 2 is the agreement, I think.
Lordship, agreement I have given the
But
agreement.
he has not given, you have not given the entire.
Enter, Lordship, to about a voluminous petition, Lordship, I have not.
So what my Lord Chief Justice is asking, there must be a clause so far as arbitration is concerned in that agreement.
You invoke that. These are disputed aspects.
Lordship, kindly see, there is, my lord, we can see page 62, my lord. 63, my lord, that is arbitration clause. Lordship, kindly see, there is the dispute mechanism, redressal mechanism, page 62,
62.
my lord. 24.1, my lord, dispute redressal system. If any dispute or difference of any kind of whatsoever shall arise in connection with or arising out of this contract or the execution of work or maintenance of the work thereunder, whether before its commencement or during the progress of works or after the termination, abandonment or breach of contract, it shall in first instance be referred for settlement to the competent authority within 45
Yes,
days.
invoke this.
My lord.
Invoke it.
Lordship, that's why my Annex 6 is there, Lordship. That's why Annex 6 is there.
What?
Lordship, but I have approached them immediately. I have approached them authorities, Lordship.
For appointment or arbitrator?
No, not arbitrate, Lordship. To reduce the Lordship, the grievance.
Then again, if
Reduce
you-
my grievance. That Annex 6, if you will,
all right.
they would, Lordship.
The dispute raised in the present writ application filed under Article 226 of the Constitution of India arises out of works contract agreement,
Lordship.
which contains dispute redressal system in clause 24 thereof. Full stop. In such view of the matter, we decline to entertain this writ application. And writ application, this application stands disposed of with a liberty to the parties to invoke the said clause.
Lordship, Annex 6 is there, Lordship. I have already approached, Lordship. Lordship, only say, Lordship, there's time stipulation that with the time stipulation, they will conclude my Lordship. That
Item 9.
time stipulation, my Lordship.
Sir,
I have already approached,
why
Lordship.
are you making this submission?
Because, Lordship,
Because
Invoke that then.
24, there is a provision for appeal also against any decision. So how can we, even before you approaching them, fix the time?
no, but only I'm appealing, Lordship, because that impugned order, they have reset to 53(2). That can maybe, Lordship.
Go there, go there. Not
Lordship,
now.
grateful, Lordship.
Item 9.
May it please your lordship.
Yes, sir.
My lord, here the petitioner is challenging the inaction of the Inspector General of Registration, Odisha, in not adhering to the provisions of the Odisha Apartment Ownership and Management Act 2023 and allowing registration of illegal sale deeds in multi-storied apartments in contravention to the Act. Your lordship, this petition flows from an earlier PIL filed by the petitioner. I may just give a brief background of the case. In the year 1982, the Odisha Apartment Ownership Act was framed, which provided for creation of association of the home buyers, and the common land and the management of a property in a multi-storied building was to be transferred to the association of allottees. But that act, the rules under that act was not properly framed, so that act never came to be worked out. Now in the year 2017, the RERA Act came into force. The RERA Act provided that the builder will form an association of allottees when the majority of the flats are booked in an apartment. And Section 17 of the Act provided that the first sale of an apartment, the flat will go to the buyer and the common areas will go to the association of allottees through a registered conveyance deed. Since in the state of Odisha, the rules were not proper for formation of association of allottees, I had filed a PIL to frame the proper rules. This honorable court, while entertaining the matter, in the interim directed that further sale deeds should be halted till proper rules are framed. And,
Where is that?
Yes, Your Lordship, that order is at page 20 of my writ petition. Page 20, Your Lordship. Your Lordship.
No, is there any mandate that rules must be framed?
No, thereafter we have gone much for because the association of allottees should come into existence. Without them, the sale deeds cannot happen. That was the mandate of the RERA Act. So the association of allottees was to be created as per the local laws. And in Odisha, the local laws were unworkable at that point. So the state government undertook in that writ petition, we will come out with a new act, completely new act. So the honorable court said, fine, you come up with a new act. In the meantime, an interim application was filed that to vacate that interim order. It was rejected. The matter went to the Honorable Supreme Court. The Honorable Supreme Court also said that without the rules being framed, appropriate legislation, sale deeds cannot be allowed to continue. So from 12th of May 2022 in the state of Odisha, all sale deeds have stopped. Registration has been stopped. Now, in the meantime, in the month of June 2023, the state government came up with the new act, this present act, Odisha Apartment Ownership and Management Act 2023. This act clearly provided that Section 8, subsection 9, if I may take your lordship, page 31, your lordship. I will just read it. Page 31, Section 8. I have annexed to my writ petition that act may not be published as of now. At page 31, Section 8 starts, your lordship.
Yes.
Your lordship, Section 8 provides the manner in which the execution of sale deeds is to take place. I'll take your lordship to the next page, page 32, subsection 9.
Subsection 9. Yes.
It provides that no deed of transfer of apartment, which is sale deed, in favor of allottees shall be executed before registration of association of allottees as per Section 15. So an association of allottees has to come into existence before registration of a sale deed can take place. And
what is come to Section 15?
15, yes. That provides the manner of Section 14 provides the manner of formation of association. 15 provides the procedure for formation of association of allottees. That Section 15 provides that an application for association of allottees shall be filed within 6 months from the date of commencement of the act and be submitted to the competent authority in such form and manner as may be prescribed.
Who is the competent authority?
That was not appointed. Neither the rules were framed.
What is the form? Is that?
No, the rules were not framed.
Oh.
Neither the competent authority was appointed, but still then the sale deeds were permitted to be registered selectively by the district sub-registrars. Without the rules being framed, without the competent authority being appointed, and without the registration of association taking place, in contravention to Section 8, subsection 9 of the Act, the sale deeds are taking.
There is no such clause that till that is done any other interim by way of
no such clause. Rather, the Indian Registration Act, Section 22A says that the registering officer shall refuse to register any instrument that relating to transfer of an immovable property, which is prohibited under any central or state act.
So as on date, Mr. Counsel, there is an admitted position that no further framing of rules or enactment is required for this purpose.
It is required.
The provision is there.
Yes,
No, the provision is there.
but
What further rule? Under which provision?
for the implementation of section 15 of the act.
No rule is required.
Yes, your lordship, rule is required so that an
Oh.
association can be created.
No, the provision is clear.
Manner of appointment of the competent authority. The state government by notification shall
Competent
appoint.
authority has been defined,
Section
that is on 2L.
2L.
Right.
Yes, state.
As I appear.
Come to section 23.
Please.
If I may enlighten your lordship.
Just a minute. Just.
Please, minutes.
Yes.
The state government may by notification appoint one or more officers not below the rank of deputy collector as the competent authority to exercise the powers conferred on it and to perform the functions within the local limit as assigned to it under this act. The
So whether
competent,
this has been complied with or not?
please, my lords, the rules have been framed, the rules have been notified.
Forget rules.
Please, minutes.
Whether competent authority, any competent authority is there in the state of Odisha or not.
As for that, I'll have to take instructions. Whether the notification regarding the competent authority.
So unless notification under section 23 is issued,
Please,
this act cannot be said to be workable.
please, minutes.
All right.
Please, minutes.
So this act was enacted in 2023 and till date you have not issued notification under section 23.
Please, minutes. The act was.
So this is an abject failure on your part.
Minutes,
Only 3 days back he has been appointed. I may assist your lordship.
3 days.
3 days back.
All right.
But till date, the registrations are continuing without any association being registered. Not a single association has been registered in the state of Odisha.
All right. So the registrations may be declared to be invalid or whatever.
Problem is that some influential persons being hand in gloves with the sub-registrars are registering the deeds which I have annexed.
Registration cannot be stopped.
Because the IGR Odisha, on my representation, he has issued a show cause notice to the sub-registrars, but nothing has happened. I have annexed those letters, your lordship.
The Odisha.
My lord, can I have one indulgence? Can I place the section 22A of the Registration Act, which provides a bar on the registration? It says that the registering official shall refuse to register any instrument relating to transfer of immovable property, the alienation or transfer of which is prohibited under the State Act or the Central Act. So here, under section 8(9) of the State Act, it clearly bars the registration of a sale deed unless an association is created. So as on date.
Now you just said that 3 days back it has already been notified,
Appointed.
right?
Let us see.
So my limited prayer is that section 8(9) should be complied with.
This is what you are doing.
Exactly. Obliged.
My lords, before, may I have one submission? My lords, under the RERA Act, my lords, there are certain projects, my lords, which are exempted from being registered under the RERA Act.
We will see later.
Please.
We will see. For the present, we are on this only.
Please.
That this act has been enacted by the state legislature in 2023. Subsection 9 of section 8 bars transfer of any apartment.
Please be notes.
without registration of association. And then it has there 15(1).
Right, so.
A competent authority is to be notified. It has to be done by a competent authority, and the competent authority is to be notified under section 23.
Please.
So this you will have to do.
Please be notes.
Otherwise, this act has no meaning.
Please be notes.
Exactly. Your
Section, subsection, sorry, क्या लिखा? नहीं, पहले. Not. We complete the order, please don't interrupt.
Exactly.
If you have to say anything, you can say.
No,
after.
no more submissions.
The Odisha Apartment Ownership and Management Act 2023 has been enacted and notified on 27/10/2023 relating to the act deals with. The act has been enacted to consolidate the laws relating to ownership of an individual apartment in a building with an undivided interest in the common areas and facilities, and to provide for better management of such apartment and for matters connected therewith or incidental thereto. So stop. Subsection 9 of section 8 of the Act in no uncertain terms bars execution of deed of transfer of apartment in favor of allottees. Bars execution allottees before registration of association of allottees as per section 15. Association of allottees stands defined under section 3 bracketed E of the Act as under E. First off, section 15 of the Act lays down a procedure for forming of forming the association of allottees. First off, the said provision requires inter alia that the application for formation of association of allottees shall within 6 months from the date of commencement of the Act be submitted to the competent authority, quote unquote, competent authority, in such form and in such manner as may be prescribed for registration of association of allottees with the persons who have been allotted, sold, or otherwise transferred the apartment, as members. Stop. Competent authority has been defined under section 3. L 3L to mean that a competent authority appointed under section 23 of the Act. Full stop. Subsection 1 of section 23 of the Act confers upon the state government power to appoint one or more persons not below the rank of deputy collector as the competent authority to exercise the powers conferred on it and to perform the functions within the local limit as assigned to it under the Act. So stop. Competent authorities have been appointed.
3 days back on.
Competent authorities have been appointed.
Yes.
Now, what is
But the rules have not been gazette notified. So
the rules are not required.
because the model bylaws for the association.
Where is that? This is what we want to know from the Act.
Yes, Your Lordship, section 16.
Just start.
The The association of allottees shall administer the affairs of the apartment and the property appurtenant thereto, including the common areas and facilities in accordance with the provisions of this Act and the bylaws of the association of allottees.
That is not to be done by the state government.
And second, no departure from variation, addition or omission from the model bylaws shall be made except with the prior approval of the competent authority. Provided that the contents and particulars of the bylaws of the association of allottees prior to the execution of registered conveyance deed shall be such as may be prescribed.
There's just one submission.
So if that is prescribed by
The rules have
rules.
been notified on 16/2/2024. Well, that's me.
Right, but whether it has been gazette notified or not, that is not. It is simply the framing of the rules.
It has been sent to the Gazette cell.
Yes, but whether it,
Must
to the
have been.
best of my
All right.
information,
That
it
is-
has not been gazette notified.
Our attention has been drawn by London State Council to a notification dated (16 to 2024) issued by Housing and Urban Development Department, Government of Odisha. In exercise of powers conferred under section 33 of the said Act, following said Act, making rules for carrying out the purposes of the Act. Where is the competent authority in this rule?
Well,
A separate notification has been issued for that.
It is further, the notification clearly mentions that no, but it come into force. Subsection 2 of sub-rule 2 of rule 1 of the rules, namely Odisha Apartment Ownership Rules. Sorry, Odisha Apartment Bracketed Ownership and Management. Oh, sorry. What is this rule?
well, this rule is Orissa Apartment. Well, let me see subsection. Rules 2024.
Odisha Apartment Bracketed Ownership and Management Rules 2024 prescribes that the rules shall come into force on the date of their publication in Official Gazette. Full stop. We have not been able to find out from the rules as to whether the competent authority within the meaning of section 15 of the Act has been notified, have been notified or not. Full stop. We are of the view that unless the Act cannot be said to be workable in the absence of a notification under section 15 of the Act. Full stop. Next, let a detailed counter affidavit be filed on behalf of the state, stating as to whether the notifications, as to whether proper notifications have been issued in tune with the requirement under section 15. 23 of the Act. 23 of the Act. First off, the state respondents, opposite parties, shall also be required to ensure that inform this court that the Act of 2023 is fully workable and all steps have been taken to ensure that the provisions of the Act are given effect to. Stop. Next, in the present proceeding in the nature of public interest litigation, it has been pointed out that the registration of apartments have been allowed in contravention of the provisions of the Act, by the sub-registrars.
Yes.
Stop. The state will also be required to inform this court about the proposed action in that regard. List this matter on 4 weeks.
4 weeks. Lordship, only one prayer. If the state can ensure that further section 8(9) is not contravened, only that much. Section 8(9) is not.
Let them do it. Let them contravene.
Sure. I have annexed sale deeds of 2024 January.
We cannot set aside the sale deed.
Yes, exactly. Those are void completely.
Item number 10.
The petitioner is the manufacturer of the furnitures of wood, crafts and plywood and lime board and other panel boards. And he has on licensee under the MSME and also on NSIC. He has participated.
Item 10, sir.
Yes.
The petitioner participated the bid floated by the opposite party number 1 through their official website, government e-marketplace, given at Annexure 2, Your Lordship, where it has been provided to apply by the 29/12/2023 for the purpose of supply of wood wall and unit and racks, wooden walls and rack installments, kitchen tops and kitchen top installments, steel wash basin in the district of Collector Mayurbhanj for Anganwadi Work Center. And in the tender bid document, the Lordship, kindly turn to Annexure 2 at page 24. There are certain documents which have been given to be supplied at the time of filing of the bid at page 24, Your Lordship.
Come to your prayer portion. What do you want? So you have been disqualified.
Yes, my lord.
On what ground?
Non-supply of the documents, Your Lordship.
Huh?
Non-supply of the documents.
So what is wrong in that?
My lord, in the bid document itself, they have given the liberty to file the same by 24 hours. Lordship, may see, kindly see for a moment at page 25 of Annexure 2. Last para, Your Lordship.
Yes.
Further, if any seller has any objection, grievance against these additional clauses or otherwise or on any aspect of the bid, they can raise their representation against the same by using the representation window provided in the bid details field seller dashboard. After logging in a seller within a 4 days of the bid publication of the on GEM, buyer is duty bound to reply to such representation and would not be allowed to open the bid if he fails to reply to the such representation. My lord, Lordship, may kindly turn to Annexure 4.
No.
At page 30, Your Lordship.
Which document you were required to submit, which you did not submit?
My lord, these documents are required, but I didn't submit. And Annexure 4, Your Lordship, they have stated that these documents I have not submitted. For that reason, I have been disqualified.
No, but did you have any objection or grievance?
Yes, sir.
What objection?
My lord, I have been disqualified, but the L1 which has been allotted with the work, he has also not defective documents, Your Lordship. Annexure 11, that GST document, GST paper he has not submitted, but he has been awarded with the work. It has been provided in the tender call notice that I have to file the document if at all it is required. I have filed very next date, I have filed along with the representation. It has not been considered at all.
So you are challenging your rejection or his selection?
My rejection along with that, they have created without considering my representation, they have allotted the work in favor of the L1, which is also the defective documents.
Where is the rejection order? Rejection of your representation.
Yes. Annexure 5, Your Lordship.
Page
31.
Yes.
My lord, representation challenge description. Sir, herein we are submitting here all documents marked out of as region out of the disqualification that is online. I could not. And thereafter representation status rejected. And the response description, the committee has not considered the same.
Where is the rejection? You file a representation that has been rejected.
Representation.
At page 30, my lord. At page 30 is the rejection, my lord.
30?
30, Annexure 4.
Disqualification 31.
33.
30, my lord. Annexure 4, my lord. He has not submitted 5 documents, my lord.
33.
30.
30.
My lord. Annexure 4.
Yes. Which are those documents where
No,
it is?
IT return copy.
Comment.
Okay, right. Okay.
No case.
Lordship, for a moment, Lordship, may kindly see. I have given the representation to the district magistrate.
No, this is an admitted fact that you did not submit these documents.
Admittedly, thereafter, I have given the representation on 20. Lordship, kindly see for a moment 31. Page 31. Their representation initiated on 21/2024. My disqualification order was passed on 19. Immediately thereafter, I have given the representation on 21/24, which has not been considered without asking any reason, and which has not been communicated, and they have put it in the website.
No, but this is an admitted fact that you did not submit.
Well, I have not submitted, but in the tender bid process, they have given the opportunity to supply all those documents within 48 hours.
Where is that?
Tender paper, page 25, Lordship.
Page 25.
Yes, Lordship.
That is not the clause.
Well,
25, where is that?
25, last para, Lordship.
Yeah.
Whether any seller has any objection, grievance against these additional clauses or otherwise or
This is
any.
something different, Mr. We already had read this.
My lord. Lordship, for a moment, Lordship, kindly see Annexure
What
11.
moment?
Annexure 11. That L1 has also not submitted the document, but he has awarded with the work.
Tell about your case first.
My lord, I admittedly have not supplied, my lord, at the time of filing the tender papers. Subsequently, I have submitted, my lord, Annexure 6 series is the document which has been supplied by me.
All right. Sorry, sir.
For a moment. Only one document, Annexure 11. Lordship, 11. At page.
Yes. What for?
At page 11, the legal name of the business, Lakshmindra Panda, and trade name, Sai Corporation, who are the L1. Lordship, turn to page 50.
So how many documents he had not submitted?
My lord, I have
No,
only
that is not his prayer, my lord.
That there is no prayer in your petition.
Lord,
Challenging.
subsequently, my lord,
Admitted things. We are just coming. The
I may pardon, Lordship. Only one submission. Lord. My lord, Annexure 8 I have given to the district magistrate. That has pending still today, my lord.
that
The petitioner has filed the representation before the Annexure 8 before the district magistrate is still pending. So that
we are rejecting your plea. The petitioner has participated in a tender process pursuant to repeat identification number GEM / 2023 / B / 4339908 dated 15/12/2023. Stop. He has been disqualified in participating the said tender process. The petitioner had responded. The petitioner had responded, participated, they also responded. Pursuant to tender process initiated by उस सेंटेंस को पूरा काटा जाए फर्स्ट रिकॉर्ड pursuant to tender notice GEM / 2023 / B / 4339908 dated 15/12/2023. The petitioner had submitted his bid. Full stop. He has, however, been disqualified by the who is the opposite party? State government. By the which opposite party? Opposite party number so and so, as he failed to submit the requisite documents. So stop. admittedly, disqualified at the stage of technical evaluation
Yes.
for want of submission of certain documents which are as under page 30. Comment portion of page 30.
Five documents.
File documents. So next, learned counsel for the petitioner has made two submissions. He has submitted that the deficit could have been made up within 24 hours of submission of tender papers, which he had done. So stop. Despite that, the petitioner's representative not to disqualify him has been rejected. So stop. He has further submitted that who is L1?
Number 6. Okay, number 5.
That OP number 6. So the party number 6.
5 or 6?
5
5 has been found to be L1. That opposite party number 5 has not been disqualified, though his papers were also not complete at the time of filing the tender papers. So next, it being an admitted position that the petitioner had not filed all the documents which was required to file, the petitioner cannot raise a grievance that he was wrongly disqualified. So stop. We accordingly do not find any merit in the writ petition, which stands dismissed. We have taken note of the fact that the petitioner has not challenged the opposite, challenge the selection of opposite party number 5 as the L1 bidder in the present writ application.
Item number 11.
Mayor, Tijolars, Malors. Wherever the petitioner has paid for a direction to the opposite parties to evict the enclosures, those have unauthorizedly occupied the medical ground, Malors, which they are creating nuisance within the campus of the medical, Malors. Let's me page 8, Malors.
In section 133 of the CRPC. So you can approach the SDO, you can invoke section 133.
The district magistrate has written a letter to the dean, Malars, the head of the institution, Malars, only to supply the list of the enclosures, Malars. Yet now they had he has not supplied the list of the enclosures. That is the main cause, Malars. To that effect, Malars, the district magistrate and collector have also written the letter, Malars.
So did you approach the district magistrate or sub-divisional magistrate?
Yes, Malars.
Where is that?
My representation is pending, Malars.
Pending.
Malars, under annexure, Malars, 3, Malars.
So a case has to be instituted under section 133 CRPC.
you can register a case.
My lord, sir, to that effect, my lord, first of my lord, sir, the Dean, my lord, wrote
And
an
annexure, what is annexure 3?
Are you aware that such a provision is there
yes, my
to
lord.
deal with such situation in the CRPC?
Have
Yes,
you
my lord.
examined? Do you know what is section 133?
My lord, sir, just I'm leading through lordship, my lord. For a while, let's me see page 8, my lord.
No, when you have a remedy, a statutory remedy, that too under CRPC, you could have invoked that. Why everyone should come to the High Court for?
That observation in my lord.
Pass an order. 133 by I'll pass again. I'll write a clear order referring to decisions of or decision of the disposed of. Disposed of. Evening.
So, last one.
Item number 12.
May I please your lordship? So here the petitioner is the licensee in respect of a Indian-made foreign liquor offshore in the district of Sundargarh, more particularly the Raulkela under the Raulkela Municipal Corporation. In Sundargarh district, the Raulkela comes within the district of Sundargarh, my lord. There are two superintendent of excise. One is at Raulkela, that is district excise office at Raulkela, and second one is, my lord, Sundargarh district excise at Sundargarh town, district headquarters. So here, the by annexure 1, the state government, the excise department resolved and decided to settle all IMFL offshore across the state through lottery. That is the notification dated annexure 1, 26 February 2021. All FLs of foreign liquor shops as well as the country liquor, my lord.
26 February 2021.
21, that is annexure 1.
What is that?
That is the notification of the government of Orissa, my lord, excise department. Page 15.
Yes.
May I read that, my lord? In exercise the power conferred by section 20 of the Odisha Excise Act 2008, read through Rule 34 of the Odisha Excise Rule, and in supersession of the notification of the government of Odisha Excise Department so-and-so, dated 28th April 2005 and 28th April 2025, published in the extraordinary issue number so-and-so of the Gazette, dated 7th June 2005, and the extraordinary issue notice number so-and-so Odisha Gazette on 7th June 2005, and all previous order, notification, if any of the subject insofar as it relates to the retail sale of IMFL and country liquor, the state government do hereby direct that the grant of exclusive privilege for retail sale through IMFL of and country liquor shop will be decided by drawal of lottery inviting application of fixed monthly consideration money in the following manner. Point 2, my lord. On receipt of this notification, the collector shall issue a notice in form number appended herewith. That form is the sale notice, my lord, where by virtue of this notice, the collector of the concerned districts were directed to invite application through sale notice within the district, my lord. According, my lord, the petitioner, he belongs to Raulkela municipal area. He participated in the sale notice and became a lottery winner. Lordship, that shop number was the sanctions of Bandho Munda IMFL offshore. It was within the Raulkela municipal corporation area. The sanction previously sanctions of, my lord. Lordship may see the annexure 2, page 27. After, as per the conditions of the sale notice, my lord, the winner has to find out the place for functioning of his shop within that sanction area, particular area, locality. So accordingly, the license was issued in my favor. I could not be able to operate because the area comes in the Raulkela Municipal Corporation area. Exclusively, the owner is the sale authority, Steel Authority of India, Raulkela. Then, my lord, Annex 3, immediately I approached the collector, Sundargarh.
The Steel Authority of India?
Raulkela, sale, my lord. That the Raulkela is, most of the area is under the sale authority area. Then the sanction area, so that was because being a lottery winner, I will have to find out the area within that particular ward. But there is no area I could not be able to find that. Then, my lord, I approached the collector. Just some alternative place I may, on objection place, I have to find out to operate my SOF. Then according Annex 3 was Annex 3 page 34. Lordship may see the last para I have mentioned. It is worthwhile to mention here that as no private land is available in Bondamunda, the area is a Bondamunda area, for opening a 5 mile off-shop, I have furnished one rent agreement for shop room located at D sector market area Bondamunda, which is in possession of one Ashok Kumar Halwai. As the said room stands recorded in the name of Steel Authority of India, the excise authority refused me verbally for opening a 5 mile off-shop in the said place. In view of the above, I fervently pray.
Your representative.
Then, my lord, immediately, the collector as well the commissioner, by Annex 4 and 5, they recommended my case to the government, state government, my lord. That should be Annex 6, page 39. This is very important, my lord. Annex 6. Sorry, my lord. This is the commissioner's. Well, Lordship, I am directed to invite reference letter number so and so on the subject that the above and say that government, after careful consideration, have been pleased to accord approval for functioning of Bondamunda IMFL off-shop at the village Dumtera. Lordship, this is a village. It was sanctioned in municipal area corporation. Then I had preferred and government had approved at Dumtera village in the district of Sundargarh for the remaining period of the year 21-22. With the condition that the consideration money and the MGQ for Bondamunda off-shop 1 number 25.
What is your problem? We have not been able to understand your grievance.
Because what happened, this shop was sanctioned originally Raulkela municipal within the municipal corporations. After winning as a lottery.
After winning, what did you do?
Lottery. I'll have to operate or open the shop in that area only.
But you did not operate.
Didn't operate.
Then?
Because due to non-ability place, my lord.
Then?
I approached the collector. The collector recommended.
What do you want now?
Now, my lordship, see, this is the government given approval to open a shop at Dumtera as a village area.
Which year? For which period?
21 and 22.
So what do you want now?
Now, what happened, my lord? That since then, I am operating there, but the government, this was the only government of the order of the government for 21-22. Accordingly, I have paid the concession money, license fee as for the urban area. Though I am operating in the rural area, but I have impelled to pay the MGQ and the concession money as a urban area.
So lottery was for urban area?
No, lottery was for urban area. Now I am operating in the rural area. Last 3 years.
So
I number of after representation, Lordship may see. Finally, the commissioner directed the superintendent to submit a factual report. The report has already been submitted by the Annexer 11 series 80, page 85.
What do you want?
So now, my last 31st is my last date of license. So thereafter, again, it has to be renewed for the 25-24 excise year. So last year, I am sustaining a loss. I am paying the heavy duty.
Then don't go for this. Oh, they are not, state is compelling you.
But this is 5 years. The shop once settled for 5 years.
Are they compelling you to do it?
No, because once I have entered into the agreement, my lord,
then
it is a settlement for 5 years. Already last 3 years, I am running the shop. The shop has made functional at the rural area. I am paying the urban area's space structure.
Why are you paying? Why are you suffering loss?
They are forcing me, my lord. That's
no,
why
they will not force you. That we can say.
The report is very well, explicit report has been submitted to the government.
That we understand.
That Annexer 11 series. That is the government take its steps, mal. Because continuously have taken all efforts and endeavor to redressal of my grievance.
See, they are not forcing you to run the shop.
Because they had sanctioned for only particular year. Because they had sanctioned for a particular excise year. Subsequent excise, there is no order from the government. But I am bound to pay because the collector is collecting me from as an urban norm.
Yes, why are you compelling him?
Lordship, kindly see page 39, my lord.
Stop compelling.
My lord, Lordship, kindly see page 39 for a moment.
From today, will not compel you.
Because Lordship, 1st April.
Tell you.
This is a question of my livelihood, my lord. Because the excise policy, they have classified
Lordship, kindly
NSC, municipality and corporation. Municipal corporation. So as for municipal corporation, they're taking the fees, my lord.
Yes.
Let's kindly see page 39 for a moment, my lord. This is a letter of the government, my lord. As per the recommendation of the excise commissioner, my lord, and so also the collector, the government has accepted his new place, my lord, subject to a condition, my lord. Yeah, I am directed to invite a reference. Let's see, got it.
Yes.
I am directed to invite a reference to a letter number such and such 25/6/21 on the subject cited above, and to say that government, after careful consideration, have been pleased to accord approval for functioning of Bondamunda IMFL offshop at village Dumerta in the district of Sundargarh for the remaining period for the year 2021-22 with a condition that the monthly C money and MGQ fixed for the Bondamunda IMFL offshop, ward number 25, Ralgala Municipal Corporation, shall be payable by the licensee, though it will function at a rural area, that is Dumtara village in the district of Sundargarh. And in view of this, he has accepted this condition.
For that particular year, 21-22. Thereafter, there is no such order from government. Since I am continuing
it is
paying
very
the rate as per the municipal corporation's urban areas norms.
So find out a place.
My lord.
Find out a place
My
in
lord,
urban area.
Let
or
me find
stop
an
it.
area.
So that's why the explicit report has been submitted to the government. That 11 series, the superintendent has submitted.
No, you have to find out.
My
Where
lord.
is the question of the superintendent?
Because lordship, as per the policy, it has to, the MGQ should be at lower side and
In
the
fact,
concession money as per the rural area.
The decision what ought to have been taken by the respondents was that though you won the lottery, but you could not find out the place, so they could have simply denied you issuance of license. So instead, you must have compelled them, must have persuaded them that please allow me to have my shop in a rural area. I'll be paying for the urban area. And on your persuasion, they issued the license. And now you have
That decision of the government for particular year, my lord. That 21-22. Subsequently, there is nothing, my lord. There is no, in absence of order, the concession money is being paid and the MGQ are being also lifted accordingly. Only my grievance, those now shops is functioning, has been made functional in rural area. I am paying the, as per the urban area. So let that be considered by the government before 31st.
No, they will not consider. They will not consider.
Let's see the policy.
Yes.
The policy I have offended, my lord, for the excise year 2022-23 and 23-24, you'll also find that page, specifically the page 52. 52. That is clause 2.4.3.9, monthly consideration money, structure for foreign liquor shop. First, category 1, 2,20,000, Bhubaneswar Municipal Corporation. Next, page 53. Ralkola Municipal Corporation comes within the category 2, that is 1,47,400. This is the C money, consideration money. But my grievance is, I am liable for category number 5 because in a rural area, only 72,000.
The responding to a sale notice issued by the collector Sundargarh, the petitioner is said to have participated and in a draw of lotteries, he was selected for IMFL off shop. Bonda Munda.
Bondo.
Bonda Munda for the excise year. Bonda Munda is what?
The name of the
Name of
ward number 25, Rautela Municipal Corporation, comma, for the excise year 2021 22. Full stop. It is the petitioner who is running the excise shop at the approved site, and the license in question is valid till March 2024. Full stop. From what has been submitted on behalf of the petitioner and what has been pleaded in the writ application, it transpires that though the petitioner's selection was for Munda IFL op shop, as the petitioner could not find out a suitable place for running the shop at the sanctioned place, based on an application made by the petitioner, he was allowed to open the shop at Dumerta
village.
Dumerta, 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 which is a rural area. So stop. It is the petitioner's grievance that whereas the petitioner is running the shop in a rural area, he is paying a royalty at the rate applicable to urban area. So stop. He, in the said background, he has filed the present writ application seeking direction to the opposite parties for refixation of the license fee. This is your submission?
My lord.
Stop. Next. Learned counsel representing the state of Bihar has drawn our attention. Orissa has drawn our attention to a letter dated 13/7/2021, which has been brought on record by way of Annexure 6 to the writ application, which reads as under. I am directed to in the district of Sundargarh. First off, it is evident from the said letter that it was that responding to the petitioners, that the petitioners had agreed to run the shop at Dumirta village, though with the condition that the monthly, what is C money?
Consideration money, that is known as
Monthly
a license fee.
consideration money and MGQ fixed for Banda Munda IMFL off shop, ward number 25, Rourkela Municipal Corporation, shall be payable by him. First off, accepting the said condition, the petitioner accepted the said condition, and accordingly license was issued in his favor for the year 2021-22
and continuing as such.
Stop. At this stage, after having continued as such till date, now the petitioner has approached this court seeking a direction to the respondents to refix the license fee
And MGQ.
and MGQ. So stop. Next, after having accepted the terms and conditions as mentioned in the letter dated 13/7/2021 for the year 2021-22 and subsequently continued for the subsequent period, comma, in our opinion, the petitioner has not been able to make out a case for this court to issue any direction as sought for by him. This application, in our opinion, has no merit and is accordingly dismissed.
Item 13.
Lordship, kindly take up this matter along with item 49, my lord. He fixed today for hearing, my lord. Similar matter, same matter.
Lord, the prayers are slightly different. This is a fresh matter. By lordship, I'm actually seeking your lordship indulgence to pass a similar order which your lordship had passed before. Which is this is a
What
fresh
is that?
matter.
Well, item 49, my lord, yesterday matter, Palito has argued that additional charges, my lord. The same matter, my lord.
Additional?
Additional charges of the Blackstone Quarry, my lord. The 295 charges. This is fixed today, my lord, as item number 49, my lord, batch case.
That additional.
And 49, my lord, they are challenging the additional charges, my lord. They have taken that stand that work was completed, agreement was signed, and thereafter the enhanced the rate, my lord.
Yes.
That matter is posted to, and this is a similar matter, my lord.
Similar.
My lord. So,
My
lordship,
lord.
take up this matter along with this 49.
Prayers here, my lord. My prayer is there, my lord. We had challenged the demand wherein after accepting a highest bid and after giving us a statutory confirmation that you are the H1, they increased the price. So we had challenged the letter demanding the increased price. My lord, here what has happened?
Same thing in the
Item 49, my lord.
No, my lord, that was there. In this case, my lord, what has happened? Our first year period is over. In fact, part of this is in that particular, it is still listed in 49. But here, my lord, what has happened after the first year is over, I asked them that, listen, please make me the second year because I'm sitting here. It's not being, the query is not being operated. Because, my lord, what happens? They give lease for every year. And because every year in the annually they calculated price, they ask me to deposit and then they do it. The first year has expired. Now I am asking for second year. I had come to your lordship had given an order that you approach them. Now they have rejected it. In a similar case, your lordship has said that while discussing whether it will be enhanced or not, please execute the lease deed in the previous amount which you have accepted. In the meantime, we'll decide whether it is higher or lower. That is what I am before your lordship. In Annexure 13, my lord, this honorable court in a similar matter had said that, listen, you had accepted their bid. You please execute the lease deed in that particular amount while we will decide whether it will be enhanced or not. That is what I was praying for, my lord. A similar order in the IA. That is what I was praying for. I am now currently before your lordship praying for a similar order as in Annexure 13. I've filed a similar order, my lord, in the IA. May I, my lord, if your lordship allow, may I invite your lordship to Annexure 13 if your lordship wants me?
Yes, 13.
My lord, at page 66.
Yes.
My lord, after the contention, if your lordship may kindly come to page 67, the relevant portion at para 8. May I state it, my lord? Page 67, para 8. I've taken the liberty of annexing the order, madam. This was passed in a IA. May I read it out, ma'am?
No, come to paragraph 8.
Yes, Your Lordship. Para 8, page 67. Since the bid of the petitioner has been accepted at rupees 1.
Because it has been accepted.
Yes, Your Lordship, that's admitted. In fact, my lord, my first year lease was already done on that price and executed. And the same has been subsequently enhanced by the district level committee, which is without jurisdiction. And as such, the same has been done relying upon a letter dated 7/4/2022, which may apply prospectively as an interim measure pending final adjudication of the writ petition. Let the petitioner deposit the admitted amount, that is 130 plus 95 per cubic meter, as against the demanded amount raised by the authority under annex to this within a period of 7 days. Hence, on accepting the amount, the opposite party is directed to execute the agreement by permitting the petitioner to proceed with the work. This is a similar writ, my lord.
But we have to examine this whether it is without jurisdiction or not in.
Yes, Your Lordship. My lord, my humble submission is while that was to be decided by Your Lordship, this was the interim order which was passed. That is what I was.
This order was passed in September 2023.
That's on another writ, my lord. This is not connected to this.
Yes.
Yes, Your Lordship. In that particular case, my lord, they had allowed, they had declared me as the H1 on a statutory form. Then they unilaterally said that no, while I was doing all the other ancillary work, they said it is enhanced. So I approach Your Lordship.
Whether this Sandeep Chandok is there, petitioner in item number 49.
28295, my lord. My lord, this particular writ is not there in that thing.
My lord, that is my lord. Good day, my lord. The other matter, item 49 is not. This matter is not included.
Is it?
There is no time.
It's not.
We will take up tomorrow. Tomorrow we will take up your matter.
My lord, along with item 49, or item 49 will be heard today, my lord.
We will see what happens then.
Grateful. My lord, may I only pray, my lord, on the top of the list, my lord?
Let us.
Grateful.
Item 14.
May please your lordship. Here I have challenged the selection of the opposite part number 3 as the highest bidder, the lower bidder for the work under annexure 1 on the ground that he has submitted certain document which is not in existence, my lord. He has filed agreement under annexure 2 saying that he has entered into an agreement with a person who has got a hot mix plant, and we have obtained information from the state pollution board that no such permission has been given for such a hot mix plant. That is annexure 3. So, my lord, what I pray, my lord, I have to bring all these facts to the authority and let them take a decision first. So I propose to file an representation before the authority.
Who are you?
I am also one of the bidder, my lord.
There are a different trend here. rather disturbed the manner in which in contract matters, casual writ applications are being filed. Unnecessary.
So that's why, my lord, I may be permitted to withdraw with a liberty to file an representation.
Petitioner seeks permission to withdraw this application. So we have not gone into the merits of the plea, which has been merits of the contentions and the grievances raised in the presented application. So the petitioner shall be at liberty to invoke, to take recourse to any other remedy as may be available to him under the law.
Item number 15.
May I please, my lords? Yes, this is a matter it's identical to which several petitions are now currently pending for.
Yes, we can dispose that of.
No, these are pending for different high courts and some interim orders only passed. Matters are still pending before Allahabad High Court, Punjab. The subject matter of challenge, my lords, here is challenging two notifications issued by CBI, my lords, purportedly in exercise of power under 186A of the GST Act, my lords. Because by virtue of 168A of the GST Act, by virtue of these two notifications, my lords, twice, my lords, CBIC has extended the date of passing the order under section 73(9), read with the time limit provided under 73 of the OGST Act and CGST Act. That's to speak precisely, so far the grievance of the petition is concerned, the outer limit, 73(10) is the outer limit, 73 is the determination proceeding. First of all, your lordship, kindly see section 168A. What are the circumstances under which power can be exercised by the government of India, my lords?
So why the matter is pending in various high courts?
Various high courts, because now courts are examining whether the situations do at all exist for which the power is invoked under 168A. Because 168 says precisely in force majeure condition, my lords. Force majeure, my lords, cannot be said to be existing perpetually. COVID has gone long back. But that was the situation because this is a case where once it is invoked by virtue of Annexure 11 and again Annexure 12. My lords, may kindly see section 168A. This is a situation which, if exists, then the power can be exercised. 168 capital A, my lords.
Of OGST or?
They're the same. Both acts, your lordship knows.
168A.
A, capital A, my lords.
Not there in my book.
That has been amended with effect from 2020. This book.
Reproduced. It's reproduced in the brief itself.
I can.
It's pending in our
in that book that is not there.
So let it be decided. If it's pending, then
no. Let's see. Let's see.
I am giving orders, Milos.
That is pending for 2017-18, as per my knowledge.
Yes,
in all other high courts, as well as this high court, only for 17-18 that is pending. That issue.
For 18-19.
So, the notification, your lordship, let me argue, your lordship.
Let him argue first.
Your lordship. Your lordship, let it come.
So may I place it, your lordship?
Just a minute.
My lords.
Yes.
So power 168, power of government to extend time limit in special circumstances. One, notwithstanding anything contained in this act.
Yeah, this we have read. But what is the issue?
There's an explanation, my lords have written. Explanation.
What is force majeure? Explanation clarify, saying for the purposes of this section, the expression force majeure means a case of war, epidemic, flood, drought, fire, cyclone, earthquake, or any other calamity caused by nature or otherwise affecting the implementation of any of the provisions of this act.
Yes.
This is the language. Now, my lords may kindly turn to the notification itself. What is the purpose of notification? That is, your lordship will find annexure 11 at page 92.
Just
Which annexure?
Annexure 11, page 92, my lords.
Yes.
Yes, in exercise of power conferred by section 168A of the Central Goods and Service Tax Act and section 21 of the Union Territory, your lordship is not concerned here, and referring to several notifications, the government on the recommendation, I am skipping all the notifications, the government on the recommendation of the council hereby extends the time limit specified under subsection 10 of section 73 for issuance of order under subsection 9 of section 73 of the said act for recovery of tax not paid, short paid, or input tax wrongly availed or utilized relating to the period as specified below, namely, the lordship is concerned with serial number 2 because I am for the year 2018-19. So for the financial year 2018-19 up to 31st day March 2024. The period is re-extended now. Same 168 tablets. Your lordship may kindly see last 3 lines of the first paragraph hereby extends the time limit specified under subsection 10 of section 73 for issuance of order under subsection 9 of section 70 of the said act for recovery of tax not paid, short paid, so on. So. And time limit, your lordship can see serial number 1 for the financial year 2018 up to 30th April 2024.
Yes.
Now, what is the implication of this extension? Extension and re-extension. If your lordship will see the provisions that is mentioned in the notification itself, saying that the order passed under section 73(9), read with 73(10) that fixes the time limit, this gets extended up to the date which I read to your lordship belows. Now, my lords may kindly see for over section 73. Section 79 and 10.
Section
73, 9 and, yes, 9. Section 73, subsection 9.
Yes.
No, sir. The proper officer shall, after considering the representation, subsection 9 minus.
Yes.
Minus. The proper officer shall, after considering the representation, if any, made by person chargeable with tax, determine the amount of tax, interest, and penalty equivalent to 10% of tax or 10,000 rupees, whichever is higher, due from such person, issue an order. Now, your subsection 10. The proper officer shall issue the order under subsection 9 within 3 years from the due date for furnishing of annual return for the financial year to which the tax not paid or short paid or input tax is wrongly availed or utilized relate to within 3 years from the date of erroneous report. So therefore, what is relevant is 3 years from the end of the date of the annual return which is required to file. That is the outer limit by now. It's a mandate, statutory mandate. Sir, what is the date for filing the annual return, minors? For that, your lordship have to minors travel to section 44, minors.
Yes.
Section 44, my lords may kindly see, subsection 1. Every registered person other than an input service distributor, a person paying tax under section 51 or 52, a casual taxable person and a non-resident taxable person shall furnish an annual return for every financial year electronically in such form and manner as be prescribed on or before the 31st day of December following the end of such financial year. So therefore, the due date for filing annual return is the 31st December of that financial year. Whereas your lordship in this case concerned for financial year 2018-19. So due date for filing annual return for this period 2018-19 falls on 31st December 2019.
Yes.
But this due date for filing annual return under section 44 was extended by the government under annexure 8 minutes. Your lordship may kindly see for a moment. Annexure 8.
9 and 10. 9 and
8, 9 and 10. Go to the annexure 8 first. Yes. Your lordship may kindly see explanation. I am not burdening your lordship to all this except the last paragraph. At page 89, annexure 8, last paragraph. My lord. Explanation. For the purpose of this section, it is hereby declared that the annual return for the period from 1st July 17 to 31st March 2018, your lordship is not concerned in this case, shall be furnished on or before, and the annual return for the period from 1/4/18 to 31/3/19 shall be furnished on or before 31/3/2022. That means the annual.
You are reading annexure 8.
Annexure 8, page 89. Last paragraph only, my lords.
What is that?
That is explanation.
Explanation, yes.
Yes. Let me read again, my lords.
Yes.
For the purpose of this section, it is here declared that the annual return for the period, you also may kindly skip 17-18 because you also is concerned here 18-19. For the period from 1st April 2018 to 31st March 2019 shall be furnished on or before 31st March 2020. Yes, that means under section 44(1), which your lordship read, the last date is 31st December 2019. That got extended by the government by virtue of this notification to 31/3/20 minutes. Then the next page, my lords may kindly see. Annexure 90. Annexure 9, page 90. The date is re-extended till 30th September 2020 for 2018-19. I am reading the last line only. Page 90, my lords may kindly, for the financial year 2018-19 till 30th September 20. My lords got it?
Yes.
My lords. Next page kindly see. Page 91. Annexure 10, page 91.
Yes.
Again, this date for furnishing annual return got re-extended in the said notification. I am placing said note. For the figures and letters for the word 31st October 20, the figures and letters 31st December 20 shall be submitted. So now substituted. That means filing of annual return purportedly under section 44(1), which was originally due as per statute to be on 31st December 2019, stood extended and re-extended by virtue of these notifications by the government till 31st December 2023.
Is it incorrectly mentioned in annexure number 10 in place of 31st September 2020?
It's 31st October. Your lordship rightly pointed out.
Because the previous annexure 9 indicates that it was until 30th September 2020. Now it has been read that 30th October is to be read as so.
Your lordship, there is probably a mistake because if the date is until 30th September
Right,
and
exactly.
this extension is on 28th October. So there is some mistake on part because 28th October they cannot extend for September month.
So this word has to be read as so.
Correct, absolutely. In any case, Millards, now this 31st December 2020 is a finally extended date, Millards, for furnishing annual return. Now, your lordship, Millards, while reconciling this date for furnishing annual return under 44(1) with that of the requirement of section 73(9) and 10, which your lordship have read, saying that the order which was to be passed under section 79 shall be passed under subsection 10 of 79 within a period of 3 years from the end of the due date for furnishing annual return. This means 31st December 20, you'll also kindly add 3 years. This will be 31st December 2023. So before 31st December 2023, order of determination of tax, interest, blah, blah, those are there. Those have been determined by virtue of section 73, 9 and 10 within 31st December 2023. Here, I will also place your lordship the notice to be issued for the purpose of assessment. That is section 73(2). That says 73(2), only one more provision, my lords may kindly take the burden of looking at this. Section 73(2), subsection.
Subsection 2 of section 70.
73, subsection 2.
73 subsection 2.
72 or 73?
73 minors.
Subsection 2.
Section 73, subsection 2 minors.
Yes.
Because the proper officer shall issue the notice under subsection 1 at least 3 months prior to the time limit specified in subsection 10 for issuance of order. Now, for passing an order under 73(9) within the time limit allowed under 73(10), a notice which is required to be issued under 73(1) is to be issued before 3 months from the time limit provided under 73(10). That means, my lord, here 73(10), if I calculate 3 years, as I said, 31st December 2023, the notice should have been minus 3 months, my lords, 31st September, 30th September. So by 30th September, on reading of this analogous provisions, my lords, it appears that the notice for adjudication, I mean determination, should be issued by 30th September 2023. What has been done here, because, and admittedly here the notice is issued on 24th December, January 2024, 25th January 2024. That is by Annexure 8.
7. 75.
I'm sorry, 7.
Yes.
Now, Miller's 3 points precisely I will be raising for lordship while challenging these 2 notifications, extending the date for passing final order on the plea of force majeure. Because as your lordship said, 168A can only be invoked under conditions of force majeure, nothing beyond yours. First is my humble submission of lordship is, which the other honorable high courts are also examining, whether my content there is absence of force majeure. Because those are all situations already over. And it is always amenable to judicial scrutiny, as and when your lordship desires. It is incumbent on the part of the council and the government also to state your lordship whether there at all subsists force majeure, which is a sine qua non of invoking 168A, whether that can at all be invoked lawfully to justify the action taken. 1. Absence of force majeure, number 1. Secondly, my humble submission is this 73(10), the very notification, milords, these 2 notifications, these admittedly, these are all, milords, delegated legislation. These are by, milords, in exercise of delegated power. Milords, one is under 172, and here they have invoked 168A. In exercise of that power, government has issued a notification. A subordinate legislation cannot overreach, milords, or transgress the act of enactment of parliament under section 73(10). Why this is so, milords? 73(10) read with section 44. Milords, when section 44 provides a time limit to file annual return, and without extending that time limit, your lordship have seen the last extension is up to, milords, 23rd December.
No, but if this submission is to be accepted, then 168A shall become OTOs.
No, milords, not OTOs, milords, not OTOs. The reason being, they have to reconcile 2 things, because one provision cannot defeat operation of the other. Admittedly, that is so, milords. There is no question one can invoke, certainly, if there is force majeure. But the question is, while invoking that provision, one cannot be allowed to defeat the other. What is the defeat? My lords, the extension which your lordship have seen from annexure 8, 9 and 10, by virtue of, my lords, those three annexures, that is notifications of the government, they from time to time extended the due date for filing annual return. My lords, if they would desire at all to save this 168 as your lordship proposing, they could have also simultaneously extended that, because the law says that no order shall be passed, my lords, after 3 years from the date of furnishing annual return. Here, annual return date you have been extending thrice or 4 times. Thrice, one more notification which are not given, but 4 times. And ultimately, you've put it to 31st December 2023, my lords. If that is so, then this cannot work in absence of, my lords, any further amendment or whatever, because this defeats operation of section 44 and also section 7310. Because the statute delegated legislation cannot violate the statutory enactment under section 7310 read with section 44 of the GST Act. That cannot be allowed to happen. You have to reconcile. You have to see that the Act is allowed to operate in its own field. So therefore, this notification...
But 168A is an exception to everything under the Act.
Absolutely correct, my lords. Correct, my lords. But at the same time, my lords have every power to insist upon whether such a power, in order to be exercised, does subsist on material grounds, force majeure. And every court is now desirous of seeking explanation. They are going to file affidavit. I don't know. We have to find out whether they have filed affidavit in those cases. They are going to file affidavit. Whether force majeure does at all exist to invoke this provision. And one more thing you also kindly bear in mind. Supposing, let us admit for a moment, you have reason to invoke 168A, extending this date of disposal till your 31st March 2024. That's what again necessity arose, necessitating again invocation of force majeure for 1 month only. Well, this is not a matter of course. As your lordship rightly, extreme power is a non-outstanding provision. So this must be exercised with power caution. And if there is material exists, you can't go on extending time and again. That is why your lordship
Force
wanted...
majeure can have cascading effect.
Exactly, my lords. Absolutely correct. You can, but you have to establish. It cannot be as a matter of course, from time to time we will go on extending. And when it defects operation...
affidavit has been filed.
I have given to your lordship 4 orders of...
No, whether affidavit has been filed in
the... It has come for the first
Let me
time.
clarify, your lordship.
It has come for the first time.
Because it is all India issue, your lordship, it is all India issue, pan-based issue. So let me clarify, subject to your lordship's acceptance. Your lordship has gone to all the provisions, your lordship, all the notification, your lordship. So I just want to hear the so-cause notice have been challenged because the so-cause notice have been issued limitation within the limitation period. Now, your lordship, I draw your lordship's attention, if your lordship will permit me, the improved notification again, your lordship. Your lordship may kindly turn to page 91. Page 91 and 92, these 2 notifications have been challenged. Your lordship may kindly look into page 91. Your lordship, in exercise, shall I place your lordship because I have to place and I have to show your lordship's another notification basing on what this notification has come forward, the force measure, your lordship. Your lordship, just 3 lines below, your lordship can turn the first SO number so and so in exercise of power, 3 lines below. And your lordship, and in partial modification of the notifications of Government of India, Ministry of Finance, Department of Revenue. Your lordship got it, your lordship. Page 91.
Yes.
Your lordship, page 91, the notification 9/2023. Your lordship, from the beginning I am placing. In exercise part of the power...
9/23 is page 90 to annexure 11, not annexure 10.
90.
90
Annexure 11. Annexure 11, your lordship.
Annexure 11.
11. In exercise of powers conferred by section 168A of the Central GST Act 2017, read with section 20 of so and so, your lordship, section 21 of so and so, your lordship, emphasis may be given. In partial modification of the notification of government, Government of India, Ministry of Finance, Revenue, number.
Where is that in partial?
Yeah, I will submit, your lordship. Just 3 lines below the latest notification, your lordship may come.
Where are you reading, Mr. In partial, that word is missing.
Fourth line.
No, no, fourth line, Your Lordship.
Fourth line.
Fourth line. In partial modification,
Yes.
in partial modification of the notification of Government of India, Ministry of Finance of Revenue, Your Lordship may pause here. Your Lordship may kindly turn to 3 lines below. Notif number 13/2022. That was the latest notification prior to this. Number 13/2022, Central Tax dated 5th July 2022, published in the Gazette of India. Your Lordship, after that 73/10/70. Now, Your Lordship, may kindly look into this notification. Your Lordship, it is very important. Here, the force measure has been done. And from this notification, partial modifying this notification, the date has been extended, Your Lordship. Your Lordship may kindly look into this notification.
How can we see this? Unless you file an affidavit.
Your Lordship, I can file, Your Lordship,
File an affidavit.
but only the extension is due to this.
Maybe.
This is missing. This petitioner could have filed this because this is continuance notification. The petitioner could have filed this. But since it has not been filed,
all notifications I also have with me, but
this notification is very important because this notification has been partially modified here. And the force measure, Your Lordship, may kindly look into the clause 2 of this notification. Because from 1st day of March 2020 to 28 February 2022, for computation period of limitation under subsection 10 of section 73, for issuance of order under section 7973 is to be deducted. So if this period and this notification, this import notification is in partial modification, so far as clause 1 has been modified, date has been modified, but this notification, so far as clause 2 and 3 are exist, Your Lordship. So this, let me clarify. This notification has been done as per the force measure 168A, and these import 2 notifications are in continuance of this notification, Your Lordship. So those periods, also Honorable Supreme Court has categorically held to deduct those periods. So that period due to COVID has been excluded for 73-10, Your Lordship. So if this period will be excluded, then another 1 year can be extended, Your Lordship.
File your affidavit.
Your Lordship, I can file it. But Your Lordship, it is a SOCO's notice, Your Lordship. SOCO's notice for assessment has
There
been
are so many cases pending on this point.
Your Lordship, before this Honorable High Court, only one case is pending.
Yes.
And in that case, no stay has been granted, Your
Yes,
Lordship.
yes, it is granted.
Let me clarify.
That
In that case, I was the arguing counsel. In that case, 2 notification has been challenged, Your Lordship. 1 notification is so far as the extension. I have the order. And so far as the other notification.
Mr. Counsel, we are ready to hear this matter and the other matter finally. Whenever you say, whenever.
Let's say what I'm playing.
We will not wait for any decision of other High Court to come.
Correct.
Before we take a decision.
Your Lordship, Honorable Gujarat High Court said, same SOCO's notice, Your Lordship.
We don't know.
Proceeding may go on.
We don't know. If you want us to decide, we will be deciding it finally.
Correct.
Without waiting for any decision from any High Court or any somewhere finality has to be reached. Why this?
What my humble prayer, Your Lordship, since SOCO's notice has been challenged for adjudication, Your Lordship, let the adjudication be continued. No final order may be passed.
All right.
Disposal.
What interim order has been passed in the other case?
Your Lordship.
Same.
No interim order.
Proceeding may continue, no final order.
That is other High Court.
What my friend is
That
saying.
is other High Court. Our High Court only issue notice.
But
only
our High
issue
Court,
notice.
in case of our High Court, Biraj, demand was already notice issued, demand raised, and Your Lordship stayed the
No.
recovery.
Demand has been stayed on other ground, not on this ground, sir. I'm the arguing counsel. I'm sorry. Your Lordship, this is the order of our High Court. Your Lordship can look into our High Court's order.
I find same notification was also under challenge.
Yes,
I don't know other issues may be there. But same
Your Lordship,
notification
our High
also under
Court,
challenge.
there are 2 notifications. Your Lordship may kindly look into paragraph. And this High Court only paragraph 5, Your Lordship, what my submission, S. Mr. Learned Standing Counsel appearing for the City GST Department. The circular number so and so,
Annexure 7 ultravirus. As per notification number 9 of this input notification is concerned, it is contended emanated from 5/7 by a limitation which has been created because of COVID-19 has been taken care of. Fresh notice has been issued and dated so and so. But he is not aware of the fact that regard so far as when the order dated High Court Gujarat in special civil application number so and so was solved in him, he was made aware. In the opinion of the court, matter require issue notice. Your Lordship, notice has been issued. Your Lordship may kindly look into the interim order. As an interim measure, it is directed the demand raised pursuant to notification 1/3/2018. That is a different notification, so far as the merit is concerned. On this notification, there is no stay. This Honorable High Court clarified this. There are two notifications has been challenged. One is whether electric supply is exempted or not. That is a notification. Honorable Gujarat High Court has quashed. That matter was pending before Honorable Supreme Court. Due to pendency of Honorable Supreme Court, this Honorable Court has stayed on that notification. And this notification, only notice has been issued. This Honorable Court has clarified that.
Where has that been clarified?
Your Lordship,
Not clarified. Para 5 by Lordship kindly, sir.
Issue notice in 5.
Same notification, 31/3/2023, which is similar to the annexure 11, annexure 11 of this petition. But all other High Courts have said proceeding may continue, no final order.
Your Lordship, in last paragraph, only that notification, 1st March 2018, demand raised pursuant to notification dated 1st March 2018 under Annexure 7, which has been quashed by other High Courts, shall remain state till dated so and so. So here, this notification of Annexure 9 has not been mentioned. Your Lordship, Honorable Court has dictated that Your Lordship may look into that Annexure 12. So far as the notification number 9/2023, 31st March 2023 under Annexure 12 is concerned. That is that.
We will hear it tomorrow.
Your Lordship.
And tomorrow we may fix a date. In this case and the other case also.
Your Lordship.
Where is that case?
I am appearing from the opposite party, number 4.
We will take. We'll see. Oh, reports the Kalna. What is the case?
Can it be
Your
after
Lordship,
lunch?
I have that given that order 1728/2024.
So we can take up both the matters for. No. Not tomorrow. Tomorrow we will take up this matter only.
Your
In
Lordship.
this case, we may pass an order for final hearing of both the cases.
Your Lordship.
All right.
Your Lordship.
Instead of interim this thing, we can.
Your Lordship. Gratefully.
Yes, may I pray? May I pray, my lords? May I pray, my lords? Item 15, Your Lordship proposed to take it tomorrow. I think Mr. Mishra is also, if Your Lordship can fix up a date and same order can be passed, my lords, it can be instead of tomorrow.
In fact, tomorrow we will pass an order directing this case and the other case to be listed together.
Okay, then it's okay. I thought, yes.
Final.
I thought probably at 2 p.m. there is any tag up, fix up matter.
No, tomorrow we will not hear that. Tomorrow we may that we are contemplating to pass an order that this case and the other case shall be listed together on a day fixed. We will give you sufficient time. You and us also.
Other companies
to prepare.
Your Lordship, with great respect, Your Lordship, that matter, that issue is pending before Honorable Supreme Court. That matter, this is an additional issue in that case. The main issue is pending before Honorable Supreme Court. The Honorable Gujarat High Court quashed that notification of 2018 Against that, the petitioner, the department, government has gone to Honorable Supreme Court.
Notification has been filed.
Your Lordship, that the merit notification, not this notification. This notification is an additional issue in that case. The main issue, so far as the merit is concerned,
Court has transferred the matters or whether Supreme Court has issued such a direction that the other high courts should not hear.
no, Your Lordship.
No.
That I have to examine. Your Lordship, I have no issue, Your Lordship. I am grateful.
Otherwise, issues cannot be decided.
Your Lordship.
If we start depending upon some decision to be taken by some other institution
Mal.
or court, then
Well, great.
Item 16, sir.
Wait, please, my lords. Lordships, in this present writ petition, my lords, we are challenging the order of cancellation of registration of the petitioner, my lords. My lords, the petitioner was first show caused under section 30 of the OGST Act, my lords.
which is the order?
My lords, right, Annexure 2 is the order, my lords. It's in page 17, my lords. It has been cancelled. The reason being the taxpayer has not filed more returns for more than 6 months. Hence, the gestation is cancelled. My lords, in similar circumstances, this honorable court, my lords, has may be permitted to pass the order, my lords, which has been passed by this honorable court, my lords.
Okay.
My lords, since the registration of the petitioner has been cancelled, the petitioner is unable to conduct the regular business activities, my lords, and he is unable to pay the returns for the subsequent period, even, my lords.
What do you want us to do?
If my lords make, my lords, the petitioner
We
at
can
this,
condone delay.
my lords, what my humble submission is, my lords, if my lords make, if my lords exercises power under section 226, my lords, there is no manner, my lords, in which the state is going to be prejudiced, my lords. If the registration of the
There is
petitioner,
no question of prejudice. If the power is vested in an authority to condone delay, only that authority can condone delay. We can make observations so that the authorities may condone delay.
my lords, I'm relying on another judgment passed by the Honorable Bombay High Court, my lords. My lords, it's in the case of Rohit Enterprises. I'm giving a copy of the said order.
So do you have any remedy against this order?
My lords, so what
Against the
statute?
order which are challenged?
My lords, what statute says, my lords? So we against a order of cancellation of registration, my lords,
Yes.
we have to file a revocation within 30 days, my lords.
Yes.
My lords, that period has already elapsed, and the extension period has already elapsed, my lords, in this present case, my lords.
Then we cannot do anything.
My lords, I'm just relying on one judgment of the Honorable Bombay High Court, my lords, where Bombay High Court has made certain findings. My lords, it's section 30 of the CGST Act and Rule 23 of the.
Wait.
I'm reading section 30 of the OGST Act, my lords. Subject to conditions as may be prescribed, any registered person whose registration is cancelled by the proper officer on his own motion may apply to such proper such officer for revocation of the cancellation of the registration in the manner prescribed within 30 days from the date of service of the cancellation order.
So no one can improve this situation.
But my lord, sir, due to
Cannot go beyond the statute.
my lords, due to the order of cancellation, resultantly the petitioner is unable to carry on the regular business activities. My
No,
lords. And
then there is a proviso that it may be extended
lords,
for a further period of
30 days, my lords. My lords,
So,
what the proviso?
Nothing can be done.
My lords, I'm
You apply for fresh registration.
my lords, for a fresh registration, my lords,
Maybe we are bound by law. We cannot change the law.
If I may assist your lordship.
Yes, please.
Your lordship, this honorable court, a coordinate bench of this honorable court, while dealing with this very matter, has condoned a delay of, I am not aware, of 558 days, your lordship.
Madam, that power cannot be exercised by the High Court. The power of condonation or delay rests with the authority. Therefore, we cannot condone the delay and ask the authority to pass an order. If the authority does not have the jurisdiction to pass an order to condone the delay, how the court can do it? The law, the statute is very specific.
Section 5 of the Limitation Act does not apply on the Supreme Court.
No question, it's so clear.
Then, your lordship, this honorable court by another order has granted liberty to move before the authority for making an application for revocation of the registration, and the authority shall consider the same.
Authority cannot consider. You may do whatever you want, but we will not make any observations contrary to law. We know our limitations.
Then, your lordship may permit me to withdraw the application.
Counsel for the we are bound by law.
Lordship, appearing for opposite party number 2.
I'm for one.
Item number 17.
My lord, I am challenging the order of the Honorable ITT under section 260A, my lord. My lord, it is a substantial question of law involves against whom the challenge we are filing the appeal.
Where is the substantial question of law?
My lord, I am good. My lord, I seek your permission.
Have you framed substantial question of law?
Yes, my lord, I have.
In your memo of appeal?
Yes, that is. They are also in the page 8, my lord.
8. Yes.
And whether in the fate and circumstance of the case and in the law ITAT is justified in deleting the addition made by the assessing officer on the ground that the order passed by the DRP was invalid, especially when the order of the DRP was not contested before the land ITAT, but the assessment order passed by the assessing officer, my lord, 1. Number 2, my lord, whether in the fact and circumstance of the case in the law and ITAT justified in holding the order passed by the DRP as invalid and deemed never been issued, especially when the intimation regarding the same has been issued with a valid deed and well within the time by the DRP, my lord. And my lord, has 3, my lord, question 3, whether in the fact and circumstance of the case and in the law and ITAT justified in deleting the addition made by the assessing officer when the draft order was already framed and served upon the assessee, even before the learned DRP was approved and based on the order of the DRP. The infant assessment has been
All the
knocked out.
questions are substantial questions, according to you.
My lord. My lord, I seek your permission if you, I can brief the issues. Section 144C, my lord, allows the constitution of DRP, my lord, dispute resolution panel it is constituted by comprising the three commissioner to review the order of the assessing official, my lord. And in for bringing the transparency and fair, a directive has been issued by the CBDT, my lord, in 2019, that one document identification number should be allotted and quoted in any communication made by the income tax authorities to the assessee, my lord. In this particular matter, my lord, the DRP, the Dispute Resolution Panel, they have issued one order in 19 June 2021 without, quoting that the document identity number, D number, my lord. And subsequently, in 27th January 2021, the same order, same intimation was made, communicated to the assessee, quoting and alerting that D, my lord. So now the issues raised that whether that 27, my lord, pardon, 27 January 2021 communication made to the assessee with the dean is not valid because the earlier one, 19 January 2021, the dean number was not there. The issue raised before the, Honorable ITAT, and it was, common order was passed without taking the consideration of the subsequent dean number which was alerted, quoted in the, assessment order and has been communicated to the assessee, my lord.
Will you pay for the other side?
This is my for admission, my lord.
All right.
Deep reply.
Weeks, because
Item number 18.
Number 18 and 19. This contempt bids are listed for the first time. Also, grant me 6 weeks time. In the meantime, I will comply the order.
after each time file reply and inform this court as to whether the court's order, the violation of which has been alleged in the contempt application has been complied with or not. So this case on
19 also. Item number 20.
May I, my lords?
20.
My lordship, this is a petition for inaction of the opposite party, government or the revenue authorities for not implementing and executing the ORERA-RERA acts during subdivision plots registration.
Why has it come for orders?
My lordship, according to RERA, ORERA form and ORERA's authorities set guidelines to follow during the registration of subplots, not to allow any subplot registration without layout approval and ORERA registration mandatory. And due to the inaction of the authorities, government losing.
Which provision you want to pay? You are not having the act with you.
Yes, my lordship. RERA Act Section 3, surplus. It is clearly states no promoter shall
advertise, market, book, sell, or offer for sale, or invite persons for purchase in any manner, any plot, apartment, building, as
Application. What is your prayer in this application?
prayer not to allow any further subdivision plots registration without layout approval and without ORERA registration.
Who are you? Is this a public interest area?
Yeah.
Have you approached them?
Yeah, already, yes, sir. Already made representation several times to Principal Secretary Revenue, Collector Khurda, and other revenue authorities, including ORERA chairman. Government losing crores of rupees revenue.
Take care.
And I filed an interim order.
Interim order you want.
Yes. No
So you
further.
are seeking interim order, therefore we should dismiss your writ application with force. Because we have filed this public.
I beg your pardon.
And you want an interim order.
No.
Are you an interested person?
No.
I have filed my counter on behalf of ORERA, my lord.
What is your stand?
My lord, may I kindly see, my lord, paragraph 3. Secretary has already written, Secretary of the Department, Housing and Urban Development Department, has already written a letter explaining the requirement of the registration, and it is being given to all sub-registers. He has, my lord, lordship, may kindly see his prayer. Such a vague prayer, my lord, you write to every authorities that they must implement. He is not giving any specific instances where it is not being implemented.
Yes.
My lordship, I have given two instances, and in this petition also.
We have taken action as against
Kindly have a glance at page 58, annexure 8. It is in Odia also, where the plot area is 312 decimal, out of which 45 decimal registered, without layout approval, without ORERA registration. Thousands of daily, they are not following the ORERA Act. Daily, almost all registration, subdivision plot registration.
Wherever he has made the allegation, you have taken the action.
Why?
Because,
Why you take action only when someone makes application?
my lord, we ensure that at least everyone adheres to that, my lord, the rules. Somewhere, wherever there is any deviation,
My lordship, in annexure 8, page 45, an RTI reply, one registering authority, sub-registrar Khandagiri, replied, our office as an institution of government of Odisha legally bound and dutifully acts as per the raw regulation instruction higher authority, as has been meticulously following the direction given by the.
We are satisfied that this public interest litigation has been instituted with verified. Do you want us to record? We understand how the PILs are filed. Do you want us to record that?
No.
The
Section 3 of RERA Act.
Real Estate Regulation. Real Estate Development Regulatory Authorities Act 2016, my lord. ORERA is a Odisha Real Estate Regulatory Authority, my lord. The act is RERA Act.
Item 21.
My lord, item 21, there is a delay of 198 days.
In this case, Millets, I am appearing on behalf of the sole respondent, Millets.
So what? Whether we should condone the delay or not?
Millets, so far as the REIT appeal is concerned, the notice was issued, but here they have filed two IA, one for condonation of delay and one for dispensing with the certified copy. Both the IA has not been attached to this. They have filed two IA, one for dispensing with the certified copy and another for condonation of delay. Both the applications are not in this petition, but they have not submitted copy of both the IAs.
Also.
But so far as the delay part is concerned, so far as the merit is concerned,
I'll serve in course of the day.
Let a copy of the IA number 4973 of 2023 and IA number 4974.
4972. 4972 and 4973.
497.
I will also serve the copy there.
Because the video has not been coming, so that it was not been reflected in the process.
Since the opposite party has been retired since 36/20/22, may I pray for the short date, Friday, this Friday, so they can start next week all. Great,
Item 22.
Lordships, indicated by your lordships. With regard to disposal of the cases instituted against the both MLS and MPs pending before different courts, my lords. Well, lords, we kindly look at order dated 11th of January 2024, my lords. Plus, we're directed to file an affidavit, my lords, take instruction.
Yes.
So I pray your lordship may grant me 2 weeks time so that I can, my lords, file
That
the.
is granted to you.
Yes, my lords. I've got the instruction. They, my lords, the steps which is be taken by the prosecution, my lords, that I have to put forth in by an affidavit. I've talked to the officers. They will give the details, my lords, so in a tabular form. So some time is required, my lords.
423 cases are still pending.
Right.
Yes, my lords. Some of
Are
the,
still pending. Those cases are pending on 11/1/2024.
right, my lords.
Whether it has come down to 422 or not.
That I have to find out because, my lords, that details, my lords, I will give you a lordship. Steps taken, what are the disposal rate before the, my lords, courts below.
Further time is allowed to comply with the order dated 11/1/2024. So, it's very clear that by the next date, the order is not compliant with, the court can be compelled to initiate against the concerned officials.
Yes, sir. Further, if your lordship can observe that the lords courts which are in session of the cases of the against the MLS and MPs, they should go on, my lords, trial of this case without any
Will
argument.
tell us, and so how many cases are pending?
So that I will come up, my lords. Then your lordship can pass that order on that day also, my lords.
That
Yes,
is the only thing.
yes, I understand, my lords.
Because that operative portion of the order of the Honorable Supreme Court, which is quoted in 11/12/23.
Yes, my lords.
That requires that this court would require the principal district sessions magistrate judges to bear the responsibility allocating subject cases to the court.
Yes.
And so all these things.
Last occasion registered given a details of the cases which are pending against the officers before different courts, my lords. That your lordship said, the my lords observed in the previous order dated 11th of December 2023.
Yes.
Item 23.
In item 23, my lord, there is a delay of 271 days. So since nobody is appearing, I will take notice if my lord permits.
There to take notice.
Nobody is appearing.
Notice.
Right.
Item 24.
May I please, your lordship? Not here. There is 51 days delay in preferring this appeal. And the appeal is arising out of a contempt proceeding.
Which for the
where
other side. Well, that I am for the respondent and my contempt application
No, no.
is for the first one, he is making the submission. Notice has been issued
No notice has been
in the
issued.
writ appeal 178. So far as
It is
conversation
for
of
the first time.
How much there?
51 days delay.
Well, and after filing for IA for compliance of the order before the Honorable Single Judge, they have taken 3 adjournments for implementation of the order. Now when their lordship has fixed the day for 1st March for filing compliance.
Why are you not accepting notice for this? He has filed the contempt, so he can accept the notice for the.
Against the contempt order, he has filed the writ appeal. The original order is
So you accept the notice.
For condemnation of delay.
respondent.
Serve the copy so that.
The opposite part number 1. The petitioner in the case accepts notice of the appeal. Really, it should be condoned.
I will file the objection.
59 days.
51.
That is not the, against the contempt order, after 6 time taken, they have filed.
Against contempt order.
Against contempt order, this writ appeal has been filed. After taking 6 adjournments for implementation.
No, we do not.
Let's see. Where is the order?
Annexure 4.
Your Lordship, kindly see the operative portion of the order passed in the writ petition. That is at page 78.
Sir, have you challenged an order passed in contempt proceeding?
Yes.
Can you?
But while exercising jurisdiction, the Honorable Single Judge has rejected the order passed pursuant to the order passed in writ petition.
Where is that?
But O Lordship, kindly see page 74. The operative portion of the order
Where
passed.
the order passed in the contempt case?
Lord, that is annexure 4, my lord. At annexure 4 at page 81.
So that is still sub judice before.
My lord.
Yes. And it was directed to be listed on 5th January 24.
Now that has been adjourned and it has been posted to 1st of March.
In January, they filed a IA for taking 2 months' time for compliance of the order. Thereafter, time was granted till February 10th. Thereafter, also taken time. Now it was posted.
If you want order, page 81, order number 1.
Yes.
24/11.
Yes. Page 81. Order dated 24/11/2020.
Are you serious?
Milord,
Are you serious about it?
no, Milord, what happened, O Lordship? For the moment, O Lordship, kindly see page 74, the operative part of the order passed in the writ petition. Page 74. The single judge directed to reconsider the matter, and so we have reconsidered the matter and passed an order. And in contempt jurisdiction, the Honorable Single Judge has rejected.
See, before when the court took up that matter on 24/11/23, what was your submission? Come to paragraph number 4. You sought for 4 weeks' time to comply the order. Now you have filed the writ appeal. Your stand is different. There you are seeking time to comply the order. You are challenging that order. So
Is this maintainable?
Not
what happened, my lord? Yes, my lord, it is maintainable.
Huh?
Maintainable.
Maintainable.
Yes, but that Lordship knows that Medinapur People's Cooperative Bank, the Honorable Apex Court has held that any order passed in exercise of contempt jurisdiction,
Is
intra-court appeal is allowed.
intra-court appeal where? This, you have filed this appeal. What appeal? This appeal is under the Contempt of Court Act.
No, that it is maintainable. Well, Lordship may keep it on Monday. I will.
They would be ready. That also come with Medinapur.
Yes, ma'am.
So they posted on behalf of the appellant. Matter on. Who is the appellant?
Appellant, since the Transport Commissioner and
Transport Court Commissioner has committed contempt.
yes, Transport Commissioner Orissa.
Monday. Item 25.
My appearance, respond,
I'll serve copy.
Yes.
Item number 25.
25, my lord, I am on behalf of Mr. P.K. Das, praying for 2 weeks after, as he is on.
As requested.
Item 26.
Item 26, I am not feeling well. I pray that this matter will be taken up quick.
Now,
Item number, I am not feeling well. I pray that this matter will be taken up quick.
when? 2 weeks. 2 weeks.
My lord, I am for the petitioner legal heirs.
Give your slip. Appearance.
Item 27.
27 become infructuous, my lord.
Infectious.
Obliged, my lord.
Item 28.
28. If I'm praying further 2 weeks time, I'm taking to issue substituted notice on opposite party number 2 by way of paper publication.
How much time?
2 weeks time.
So who is opposite party number 2?
Opposite party number 2 is the workman.
And you are a social service organization.
I am. The management, we are challenging the dismissal of a petition to set aside.
You are a social service organization.
I am.
And you are fighting against the workman.
Yes. We're just challenging the order passed for dismissal of a petition to set aside an ex parte award under Order 9 Rule 13.
What is the ground?
The ground is that when the order was passed that the arguments will be taken up later, our advocate had thought that later as in a later date, but on the very same day at a later time, the matter was taken up for argument. That is the cause.
You are not satisfied. This is 2012 matter.
Yes, sir.
13 matter.
13.
So you can argue in his absence. We are there for him. We are there for workmen.
Your Lordship may see. On the date of argument, we had filed on the date of passing of the order. On the date of argument, we had filed an order to.
So where is the award?
The award is at the impugned order is at Annexure 1. The award is at the order is at we have not filed the award. We filed the impugned order wherein our petition to set aside that ex parte award has been dismissed.
This is 2012 order. This is not an award.
We have not annexed the award.
Award is not there. This you have challenged this order 13/12/2012.
Yes, sir.
Subsequently, award has been passed.
Award has been passed on 22nd 11/2011.
11.
Yes.
Set aside the expertise. That was
Shocking. That is solely because he is a workman.
does not have the resources.
We are ready for rehearing. We are not shying away from the award.
Yes, you see, this matter has remained pending for last 11 years. The award was made in 2011. The award was passed in your absence.
Yes.
Subsequently, you make an application for recall of the award. How far the workman can fight? He has his own limitation.
Rehearing the matter can be
What is the
reheard.
operative part of that award?
But we have not annexed the award.
No.
This impugned order.
Yes.
Impugned order, it has been stated that
No, what is there in that award dated 22/11/2011? What you are supposed to do as per that award?
if I don't have the copy of that award,
Bring that on record.
I'll bring that on record.
For the petitioner is permitted to bring on record the award which has been passed by the tribunal by filing an additional affidavit. So for the said purpose, let the matter be listed on. Matter is adjourned till 1 week.
Item 29.
Wait, please, Your Lordship. Your Lordship, today I have been served with an IA, copy of the IA, Your Lordship. Actually, there have been 45 disputants in this case, Your Lordship. They are weaver members of a cooperative society. And as per the orders of this Honorable Court, Your Lordship, 25 disputants have been paid the interim relief of 20,000 each, Your Lordship. And the petition which is filed today, that says that 10 workmen have already, 10 of them have already died, Your Lordship. Their legal heirs are brought on record. So I'll have to verify this amount, this particular statement, and will give them, if they are entitled, this will be given, Your Lordship. So I want only 3 weeks' time, Your Lordship.
10 also living, my lord. Out of 45, 20 they have paid, 20,000.
No, 25 have been paid. 25 have been paid.
20 are left, my lord. 10 is living, 10 is died. So the legal heirs, they are seeking that that amount may be paid to the legal heirs. We have five.
I'll check up, Your Lordship. I'll check up.
I'll file.
Anybody is entitled, definitely will be paid, Your Lordship.
I have submitted bank account and Aadhaar also before the authority. Let them take action also, they will pay or not. The order is there from 9/1/23, my lord. More than 1 year has been passed.
The persons who are not dead, so for them at least there is no problem.
25 have been paid, Your
No,
Lordship.
that is all right.
But with regard to the others, there have been some distinguishing factors like their names do not tally with the roles which were on their old rolls. Names did not tally their father.
No, that is not true. They have not
that was the
taken instruction by it.
I'll
We have
definitely
made
find that.
application. What they wanted, we have also given. We have also given affidavits, my lord.
Yes, yes.
But they have not verifying that.
No, that is
Not
under
releasing
verification.
them
This
out.
will be now under
No,
verification.
no order was passed. That is my application itself in the annexure B, my lord. Nothing has been
Yes.
done. In spite of a judicial order, my lord. The poor workmen are suffering. my lord.
Your Lordship, this is the last order, that is 4/12/2023. That was the order given.
Court also directed to
Yes.
file further affidavit clarifying all these things.
That's what I've been filed. I've been served today.
4/12.
4/12, Your Lordship. Order number 15.
And what about the remaining 10? What is your stand?
10, your lordship, that is under verification because yesterday night I could not be able to talk to them. Today morning I could be able to talk to them. They're saying that we'll be sending shortly the entire thing, entire list, your lordship. Whoever is available, they will be paid definitely, your lordship. I'll take only 2-3 weeks time. Yes.
Those are living.
Yes, yes.
Those are tired, they are legal heirs. They are.
He has brought on today, your lordship.
No, I've already submitted before the authority long before.
No, today.
Go directed to file detail.
Yes.
Today.
There.
My lord.
He has given today, your lordship.
Account number of
Online transfers are being made, your lordship. Online transfers being made.
Have submitted in February, my lord.
No.
Please, Mr. This is not the way. Please.
Maintain the
Yes.
proper.
Everything on record. I am
All right.
placing everything from record, my lord.
Still.
No means, my lord, it will be difficult.
On an assurance given by the senior counsel appearing on behalf of the petitioners. Petitioner or petitioners? Petitioners.
One, your lordship. It's long.
Petitioner.
One only.
That out of 20 workmen,
No, 45. Acha, sir.
out of 20 workmen who have not been paid,
Yes.
comma, 10
Yes.
are not alive. 10 are not alive.
Well, 10 are not alive. Yes.
10 are not alive. And the petitioner shall ensure payment to the living workman
Yes.
within 2 weeks.
One more week, your lordship.
3 weeks.
Yes.
Stop. It has been argued on behalf of the workmen that the management should pay to the legal heirs of the deceased workman. The details have been furnished.
Yes.
My lord, everything has been.
IA number 19535 of 2023.
Aadhaar, bank detail, affidavit, everything has been furnished.
Details of which have been furnished in IA number
19535 of 2023.
1953 of 2023.
Yes.
So stop. List this matter on 4 weeks for and senior counsel for the petitioners to inform this court
Yes.
as to whether court as regards the developments in the meanwhile
Yes.
in the direction of payment to the workmen / legal heirs of the deceased workmen.
Yes. Yes. Grateful.
Item number 30.
Your lordship granted 4 weeks. It will be listed after 4 weeks.
4 weeks.
Grateful.
Acting, my lord, I am appearing for the opposite party number 2 workman. My lord, I was granted time to file counter, but I am unable to. 2 weeks more time may be granted. So that
As well.
2 weeks further time is allowed. There are 2014 matters. 2
Interim order is there, that should be.
weeks further time is allowed for the workmen, for the opposite parties to file counter affidavit. So interim order shall continue in the meanwhile.
31.
May I please, your lordship?
But there are 2 other sub items, the same order. The 3 matters together listed.
30.
All the matters, the same order. DPO.
Item 31.
May I please, your lordship? I'm appearing on behalf of Mr. S.B. Jena. Your lordship, in this matter, the petitioner, the workman,
challenging the award passed by the Law and Labour Court Bhubaneswar on dated 4th July 2011, Your Lordship. 2014, 4th July 2014. Your Lordship, kindly have a glance to the award. Starts from page 17 in Annexure 3. The relevant portion, page 23, Your Lordship. Para 8.
Yes.
The first party management having suppressed material documents to rebut the claim of the second party workman, this court on the basis of the evidence adduced by the second party workman, both oral and documentary, comes to a conclusion that the second party workman had rendered continuous service under the first party management from dated 10/6/96 till 7/12/2010, and in view of admitted non-compliance of the provision of section 25F of the Industrial Dispute Act 1947 by the first party management, the refusal of employment of the workman with effect from 7/12/2010, which amounts to retrenchment, is neither legal nor justified. Your Lordship, after held that it is neither legal nor justified, only the compensation of rupees 2 lakh has been allowed. And I am challenging such award, Your Lordship. Therefore, Your Lordship, after giving my 14 years to the management, Your Lordship, I am only, the award has been given only rupees 2 lakh, Your Lordship. And Your Lordship, kindly have a glance to the last para.
So what amount should have been given to you?
Your Lordship, it may be calculated as per the last wage drawn by the workman, Your Lordship.
Is there any formula?
Lordship,
no, you are challenging an order on the ground that the amount which has been paid to you is less than what ought to have been paid to you. Then the question is, what amount ought to have been paid to you? And on what basis?
On the basis of last wage drawn by the workman, Lordship.
Last wage drawn, what was the last wage drawn?
The amount has not been mentioned, Your Lordship.
Then,
May submit it is 103 per day, it is semi-skilled worker. I'm for the opposite party, but and diluted.
Yes.
At that time, the wage was for the semi-skilled worker, which is a temporary hand. It is an admitted fact and it's a finding of the court that this is a temporary hand. It is mentioned in the judgment itself. But in the interest of the workman itself, at that time, the daily payment, he was on the daily wage basis, 103 rupees. So per month, it was 3,000 somewhat, 3,090 rupees. And in fact, that amount 2 lakh is also on a higher side because that was amount to 6 years of his salary, without any working man. For that reason, the learning court below has awarded this amount at that time, and at that time we had also already paid that amount in 2015. The judgment was of 4th of July 2014. And after this case was filed, we as per the court's order, we had paid that amount, but it was not encashed. Later, only now they have taken up this check, and till now, what my understanding is that they have not again they have not encashed it, but they have received the check.
Your Lordship, the workman is not interested to receive that 2 lakh amount. Your Lordship, the workman is trying to challenge this award, Your Lordship. And Your Lordship, kindly fix it to next week. I will give some decision of the Honorable Supreme Court. So far as
these are 2014 matters, and in every case this is happening. I'm counsel for the petitioner that he is not in a position today to address this court as to how
the award made by the industrial tribunal for payment of rupees 2 lakh.
Labor court matter. I'm sorry, labor court matter. Bhubaneswar labor court.
Sorry, Bhubaneswar Labor Court for payment of rupees 2 lakh after having held the petitioner's retrenchment illegal is not justified. क्या लिखा?
After having held the petition,
So award is also lump sum compensation.
after having held the petition, yes, but illegal, is not justified.
Is not justified. So he seeks adjournments. So place this case on 1 week. The court makes it clear that no further adjournment shall be granted.
Item 32.
The petitioner is a workman. 52, my lord, on behalf of Mr. Mahapatra, my lord, for OP2, my lord, may be taken up one day after, my lord, because the say 1 day after there is some further developments are there, we'll file a further affidavit regarding to that, taken up.
You are for?
I am for the OP2, my lord. Management.
Counsel for the
Management.
opposite party number 2 states that in view of certain developments having taken place recently, an affidavit is required to be filed.
Yes,
So this affidavit shall be filed by
1 week time may be given, we will file.
filed by 1 week. So stop place this case on 2 weeks.
Item 33.
My lord, here the petitioner challenge the order under Annexure 17, page 64, my lord.
Oral order?
My lord,
Which order?
Annexure 17, page 64, my lord.
17. All.
In which, my lord, the claim of the petitioner having been rejected, they have,
This is 3140.
my lord,
This is 3140. Annexure 17.
3140.
Yes.
Annexure 17 at page 64, my lord.
Yes.
Your lordship will kindly see, by virtue of an writ application, it was, my lord, sent to the Commissioner of Municipal Commissioner Berhampur to decide the issue relating to a construction of shelter for urban homeless, and, my lord, for whether in that place that homeless building will be constructed, or by, my lord, a elevated water reservoir will be constructed, my lord. That issue was heard by the Commissioner Berhampur Municipal Corporation and was rejected, my lord. In para 65.
No, but come to page 65, last paragraph.
Yes, that is the claim of the petitioners have been rejected, and the commissioner has.
What can be done?
Kindly, ma'am. After filing the writ application in 2016, there was an interim order, status quo. Now, I, my lord, pray before your lordship, my lord. Your lordship may dispose of 8 years have already been passed in the meantime, my lord. Your lordship, no work has been commenced. Therefore, my lord, my prayer before your lordship may dispose of the writ application, granting liberty to the petitioner to again approach the Commissioner Berhampur Municipal Corporation.
What?
Well, whether in during that time, whether that decision have been changed or whatever, my lord, 8 years have been passed.
8 years have been passed. If there is any fresh cause of action, you will be at liberty. But we will not remand the matter back. It will be open to you. This we can object.
Your lordship,
The
Observe that.
petitioner has put to challenge an order dated 18/1/2016 passed by the Commissioner Berhampur Municipal Corporation. Berhampur Municipal Corporation in compliance of an order of this court passed in WP bracketed C number 14187 of 2015. So stop.
They disposed of on 17/11/2015, madam. That date is not there. But it was disposed of on 17/11/2015.
The petitioner, comma, a group of local people, comma, were opposing construction of shelter for urban homeless, bracketed SUH, building over a disputed land. So stop. The commissioner of the municipal corporation rejected the representation filed by the petitioners, taking into account the fact that the construction work had already started. So stop. Next. More than 8 years after passing of the said order, we are of the view that no useful purpose shall be served by entertaining this application. So, learned counsel for the petitioner has argued that no substantial progress has been made
By virtue of the interim order passed by this honorable court.
in construction of the building. Stop. Without expressing any opinion, we dispose of this writ application with a liberty to the petitioner to approach appropriate forum if the cause of action still survives.
May I please? In this case, Lordship, I challenge Annex 1. This order passed by the Judicial Authority declined to register in my name, stating therein that the land has already resumption by the government. Under Milord, the 3B or 7, I don't know, Milord. Before Lordship going into detail of this, I'm just basing on date chart. Lordship, kindly. In their 73, Milord, one Bhaskar Tandi, this land was allotted in his name and lease have been granted in his name.
What is the order passed?
Order passed, Your Lordship, this passed. I'm just basing, Lord, Lord, the case record put up today, so and so, Lord, but Your Lordship, 6th line below.
Page number.
Reject.
Come against this order.
Yes, Your Lordship.
This order must have been
Other forum.
No, it is single, but it was
This is a single bench matter because it is arising out of a mutation case.
But it is a
Must be having some forum of appeal.
This is appeal.
This is not appealable. As for their counter, they are revisable. Sorry, I'm just missing. Because, my lord, why I'm saying, lord, I understand that difficulty I have, my lord, I understand. But what is the reason for declining, lord? Kindly see, my lord. Because it cannot be settled in the appeal even. Your lordship has, cannot be settled in the appeal or revision itself. Because this honorable court, my lord, in pays a judgment, my lord, in Narottaram case by clarifying equity. I'm just placing the 3 line thereafter, your lordship, my lord, what he has stated, my lord. But the SRD has been registered before the final publication.
No, but what Mr. Mahanti says that whether it is correct that it's a single bench matter.
But the first initial letters are granted protection by the division bench because it is a lease matter. It is a lease matter, my lord.
What is this? It is a mutation.
It is mutation, but arising out of lease.
No, lease is nothing.
Yes, we have this core issue is the lease. Without any notice to me, my lord, I have a 4th and 5th purchase. Verifying the potta, my lord, I'm a lady, my lord, on payment, my lord, tax receipt are issued. All, my lord, without any notice to me, lord, your lordship remember, without giving any notice, my lord, this property has been went back to the government khata. We have no knowledge, my lord, because my purchase, my lord, leaseholder is I am the 4th purchaser. Therefore, my lordship, I have given the date chart wherein, my lord, I have stated that first I have paid sale somebody else, thereafter sell somebody else, thereafter potta was paid in favor of somebody else. I am verifying the potta and purchase.
Just think of a situation where an order passed by, what is the rank, circle officer?
We got the additional tahsildar. Additional tahsildar.
Additional tahsildar.
Yes.
You have come directly to the court of
Yes.
justice.
Yes. Because reason being, lord.
Reason being what?
Reason being, lord, without any notice, lord, we don't know.
You could have challenged before the appellate authority. Same point you could have taken.
Lord, my 1 minute, lord. Appellate cannot, lord, adjudicate this issue. Why, lord? Why I am saying so, lord? Because these issues were carried out, lord, so many times these honorable courts, lord. Not my issue, lord, other issues. These honorable court render a judgment, lord. Your lordship see the Narottaram case, lord, judgment ready for, lord, 2/1/2023, lord. Your lordship kindly see, lord. Why am otherwise, lord, I conscious of that. That is the appeal, lord. I have never come to this honorable court because we don't have any order, lord. What I have challenged before the authority?
What is that particular mutation?
Mutation manual. Appellate.
And your lordship, I have last occasion, lordship directed me that we produce the lease deed. Therefore, I file application before the authority, lord. Lord, the till date, lord, they are not giving me. Therefore, I file a IA for call for the record.
What is that provision, Mr. Mahanti?
That is
that appeal provision.
Odisha Survey Settlement Manual.
No, appeal under the mutation.
Your counter says.
Counter?
Your counter says. His counter says, lord.
No.
Rule 34 of Odisha.
34.
Yes. Odisha Survey and Settlement Rules. And
34.
So in the mutation manual, nothing has been dealt with that. Suppose it's a case where the mutation was rejected, torn down, then what he has to.
Lord, that is the so far as the merit of the case is concerned. If your lordship will permit me, I will submit few words on the merit of the case.
Come on the merit of the case. First of all, leave it us.
Yes.
You could have said that if you had any preliminary objection to raise, you could have raised.
Yes, preliminary objection is regarding maintainability of the writ.
On what ground?
On the ground that the impugned order is revisable. That I have stated in the counter affidavit, your lordship may see. paragraph 92 of the Odisha Mutation Manual. Therefore, the writ application is liable to be dismissed because
You are referring to mutation
manual.
92 or 90?
92.
Huh?
Under paragraph 6 of my counter affidavit.
What is that?
Paragraph 6 may kindly be seen. Mutation manual.
Yes, you cannot challenge in appeal this order.
Because on the ground, my lord, your lordship, I am giving the judgment, your lordship, see the last paragraph IB. Whether the land in question are recorded of final publication ROR in the name of the government, the entry will stand cancelled by virtue of the order of ASO will proceed to record in favor of the respective petitioner. I have no such order, my lord. Because I am a bona fide purchaser, fourth purchaser, my lord. Verifying the POTA record of right and rent receipt, my lord, I have enclosed. Earlier, my lord. I have purchased, my lord. How could I challenge? What is the order I have to challenge before the ASO or the authority to correction of the POTA? Now, my lord, the situation is POTA has been.
No, the order which you are challenging here,
Yes.
you could not challenge it before the appellate authority.
But appellate cannot, my lord, adjudicate this issue on the simple same ground, my lord. The POTA has been corrected, my lord, in the name of the government. So if it is the name of the government, I have to challenge because my lord, the Board of Revenue. Board of Revenue had to challenge, there must be order in my favor. I have no way connected, my lord, in this case. I have no way connected because I am not the leasehold landowner. I am not this next purchaser. I am the purchaser after verifying the POTA and the rent receipt. So the fundamental principle is I
Who is aggrieved? Finally.
I am aggrieved.
Then you have to challenge.
So my lord, they have to give a notice for that. Because
take this plea that no notice was given to you.
Suppose, my lord, I will take a chance, my lord, to give an opportunity. What, my lord, they will develop? They have already transferred the property.
That we don't know.
No, that is their stand, my lord. They have stated in their counter affidavit. Kindly see, my lord.
All right.
That is their counter affidavit, my lord. So, my lord, after, my lord, 2018, your lordship has protected me. Now I am going for appeal. Your lordship kindly visualize the situation, my lord.
Sorry. As you wish. We will decide. Either we decide or you take up.
Your lordship, give limitation may be considered so that it's pending before this honorable court.
Counsel for the petitioner, after some argument, seeks permission to withdraw this writ application with the liberty to challenge the impugned order dated.
My lord, that is order dated 3/1/3/10/2000.
No, it's
4/9/2017.
4/9/2017 before the competent authority under which provision?
Your lordship may see paragraph 92 of the Odisha Mutation Manual.
42.
92.
But who is the authority?
That is sub-collector. Sub-collector is the authority. Para 6 of my counter affidavit.
92 of what is this? Of the Odisha Mutation Manual. Manual, 1962. Stop. This application is disposed of with the liberty as sought. Or stop. Apparently, the appeal would be time barred. So accordingly, it is observed that the appellate authority shall be required to consider the petitioner's appeal, a petitioner's application for condonation of delay, comma, if any appeal is filed within 15 days from today, comma, Keeping in mind, keeping in mind the fact that the petitioner had approached this court by filing the present writ application, which remained pending till disposal of till its disposal by the present order. Stop. Yes. Application becomes disposed of with the observation.
My lordship, annexure 1 may be written, my lord, a certified copy because annexure 1 may be written by substituting the status quo.
The certified copy of, let the certified copy of
annexure 1,
the impugned order bracketed annexure 1 be returned to the learned counsel for the petitioner for him to enable quick filing of the appeal before the appellate authority. Yes. Interlocutory applications stand as for interim order is located. Yes,
item 35.
Your lordship, on behalf of the petitioner, I seek some time to file proper affidavit.
Why?
Your lordship, the affidavit is not in the prescribed format, so we seek some time.
Affidavit.
But lordship, in this case, I am appearing for opinion or 5.
No affidavit. Yes.
Lordship, I am appearing for opinion or 5. I am the successful bidder and I have already executed agreement, lordship. And there is no interim order. Let them permit to allow lordship to operate, lordship, because of pending date application.
So what has he done?
Only has filed a petition, lordship.
So has he stopped you?
But because of pending date application, the government, state government has stopped me, lordship. No interim order, nothing, lordship.
Pendency is nothing.
That is no order there, lordship.
Pendency.
Only that in the name of pendency, they have stopped me, lordship.
So you want reverse interim order?
No, lordship. But only clarification, lordship, because there is no interim order, only that clarification.
Yes.
No order, interim order.
But government has stopped me, lordship.
2 weeks.
Item 36.
Obliged.
36, I need some time to file and rejoinder to the counter affidavit, my friend. I pray lordship may grant me 2 weeks time to file the rejoinder.
I'm appealing for the opposite parties in this case, madam.
2 weeks time to file the rejoinder affidavit.
2 weeks time is allowed for the estate to file rejoinder affidavit.
No. May I pray, lordship, there is an interim order that may be till that date or Lord may extend the interim order.
Who is the, you are?
I am for the petitioner, Lord.
Who is petitioner?
I'm not, of course, we are on the other side. I am for the petitioner, Lord. It's not connected to the state government. I mean, it's a.
I'm appealing for the Odisha Power Transmission Corporation and my lord friend is appealing for the petitioner.
Allowed to the petitioner to file the counter affidavit. In this case, 2 weeks. Yes.
Item 37. May I please, your lords? In this case,
for the respondent, my lord.
notice has been issued on the question of limitation. There is a 59 days delay.
I am
How many?
59 days, because that COVID period is excluded 59 days.
It's a 225 days.
225 COVID period. I am saying that COVID period is excluded till 1/6. So this was filed on 29/7/2022. From 1/6 to 29/7 to the 59 days.
Similar ground, my lord, a number of writ appeals have been rejected on the ground of limitation.
No, those
My lord,
cases are different.
Registry has pointed out it is 256 days.
I mean, that till 1/6 that will be excluded because in view of the honorable apex court judgment.
Till 1/6?
2022.
Sure.
I have filed an objection to the IA, my lord.
Objection copy not served.
Order of the Honorable Supreme Court.
I have copies with my. I can kind of kill or some. pass it for some time, I can.
Tomorrow?
Yes.
38.
And may I pray, my lord, he has filed an objection. Let a copy of this be served to me.
Take it from me.
Item 38.
38.
My lord, item 38, last occasion I have taken time to file the rejoinder affidavit. My lord, with 2 days time is required to me for filing the rejoinder affidavit because rejoinder affidavit is ready and the petitioner has to come and sign the same.
As requested on behalf of the petitioner, list this matter on 1 week so as to enable him to file the rejoinder affidavit.
Interim order may be continued.
Interim order shall continue in the.
I do not 39. In debt, man. My lord is placing in debt.
1 week.
1 week. Become 39. I do not 40.
Lordship, in fact, in the meantime, the period of tender has already been completed, Lordship. But Lordship kindly see Annexure 9, page 109.
So what did you submit?
Lordship, because Lordship, the other, Lordship kindly see the order of the character, portion Lordship's order, kindly only page 110, last part.
Yes.
Lordship, just a minute, last paragraph. With regard to blacklisting of the transport contractor, page 110, Lordship.
Yes.
With regard to blacklisting of the transport contractor, after due consideration, it is felt that blacklisting is too harsh a punishment at this stage when the criminal investigation is ongoing. Till finalization of the criminal investigation oblique proceeding, the transport contractor is barred from participating in the civil supply contracts. If the criminal intention of transport contract is established, blacklisting is to be, Lordship, give an effect to Lordship, perhaps that is. So, Lord, in the meantime, Lordship, already I have been, that criminal charge has been quashed, and Lordship, the period has already gone.
You should be happy.
But so that's why,
He is otherwise happy.
Lordship, this.
Because we have not insisted for blacklist.
So with such observation and my, if they have
question of them.
If the forfeited Lordship, the amounts, Lordship, that are,
This is the order which is under challenge.
Lordship, order of Lordship, blacklisting and cancellation of contract was under challenge, Lordship.
So that is over.
That is over, Lordship.
That contract work must have been completed.
Completed, Lordship, by this time.
My lord, in fact, my lord, he was a transport contractor for transporting the PDS goods, my lord. The allegation is that he had moved the truck, my lord, on the opposite way. And there was a FIR and there was an inquiry and there was show cause.
But that has been caused.
Yes, Lordship.
That has been caused.
And
I have no instruction, my lord.
My contention, Lordship, that direction was on there at their behest, not without my knowledge.
Opposite direction means what?
Lordship.
My lord, that was a direct
to challenge an order dated 19/5/2022 passed by the collector Kalahandi. (11/5) or 19/5?
No, 11/5 it was passed, but it was
11 subsequent
11/5/2022 passed by the collector Kalahandi. To stop. The concluding paragraph of the said order indicates that according to that in the opinion of the collector, blacklisting the petitioner would have been harsh, particularly when a criminal investigation was going on. Stop. The collector observed in his order that till finalization of the criminal investigation proceeding.
Investigation.
Criminal investigation plus public proceeding.
Proceeding.
That's right.
The petitioner bracketed transport contractor would be barred from participating in civil supplies contract. Full stop. And you could not see what is there if further, if criminal intention of the petitioner was established, comma,
Blacklisting is to be done.
blacklisting was to be given effect to. Full stop. Next, learned counsel for the petitioner has informed this court that the criminal prosecution has been quashed.
Quashed, Lordship, by this honorable court.
Quashed. And in such view of the matter, period
of contract. Period of contract also, Lordship.
In such view of the matter, the impugned order, to the extent it relates to blacklisting, has become meaningless. Stop. Further, the period of contract has also expired.
Lordship.
Stop. Next, in such view of the matter, this application stands disposed of as having become infructuous.
Only one liberty, Lordship. I will pray for refund of my security deposit that is there.
My lord, the contract was cancelled, my lord.
Contract was
Cancelled. So how you will claim
I'll
it?
pray for you take a decision. I will approach before authority to refund my security deposit that is there.
Petitioner shall be at liberty to take steps for refund of his security.
Deposit. Lordship. Grateful. Lordship.
Item 41.
May I be permitted to address your lordship through virtual mode?
Please.
Well, here in the seat petition,
the opposite parties shall be at liberty to take appropriate decision on any such application for refund of the security deposit.
Lordship.
Item number 41.
may I please your lordship? Well, here the petitioner is a successful bidder in respect of a sand quarry. But upon completion of all formalities, the leach quarry was created by the annexure 4, page 19.
This is WPC 15613.
Yes, your lordship.
Yes.
But I am a successful bidder in respect of a sand quarry. And this quarry lease was created, that is at annexure 4, page 19. This was for 5 years, my lord. But because of the interference of outsiders or the local villagers, I could not commence the operation of the sand quarry. And it was also fairly admitted by the Land Council for the state on 7 July 2022. This was taken note by your lordship by order number 2 also. And in their counter affidavit, they have also admitted. In view of the changing circumstance, I have to amend my prayer because initially my prayer was to extend for 1 year and to direct the opposite parties to create an environment for operation of the sand quarry. But since they have admitted that there is disturbance or annoyance of the local villagers for which I am not able to operate, I would like to amend my prayer suitably.
Do it. Who is?
My council state is appearing, my lord. They have admitted.
Well, he wants to amend his prayer. He has not submitted an amendment petition. Let him submit an application.
So he said that he will file an
Let him file an application.
Yes, that is it. The changing circumstances.
The petitioner who has joined online seeks adjournment to file an interlocutory application seeking amendment in the prayer portion of the writ petition. As requested, please discuss on 1 week.
2 weeks, your lordship. It's
2
far
weeks.
away from Cuttack.
2 weeks.
Deeply obliged.
Item number 42.
I pray further 2 weeks time to put the counter. I have received the Parawaj comments within 2 weeks.
2 weeks for the time.
And it can be disposed of also. Because Lordship, kindly see, I had challenged the recommendation of rescission proposal of 2000 Lordship, the 22. In the meantime, 24 Lordship, and in the meantime, I have instruction, I have completed almost all the works also, Lordship. So only Lordship say, I will approach before the authority, because only the rest of part they will do, Lordship, because I have completed the work. It was
The petition is a premature one.
Yes, that's why I am saying I will approach there. I have already completed the work, Lordship, in the meantime.
Lord Counsel, then you withdraw it.
Lordship, because of the constitutional benefits there, Lordship, I will withdraw to approach them to Lordship to
All right.
Lordship.
Lord Counsel, for the petitioner, after some argument, seeks permission to withdraw this writ application with a liberty to approach the authorities for a redressal of his pending grievances.
Lordship. Well, one line submission, I have completed the work that may be recorded, Lordship. In the meantime, I have completed the entire work, Lordship.
Lord Counsel for the petitioner has submitted that the petitioner has completed the
Work in question.
in the meanwhile. So we need not make any comment upon such submission
Lordship.
in the present order. First off, it will be open for the respondents, opposite parties to take their own decision.
Lordship. Grateful.
Item number 43.
May I please, Lordship? Item 43, my lord, 4 weeks time to file rejoinder.
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 Yes,
I am appearing for the opposite party.
4 weeks. I am allowed for the petitioner to file the rejoinder affidavit.
Only for the open number 4.
Open.
Item 44.
May I please, your lordship? My lord, the petitioner challenges the decision of the OP number 1, leaving me for further bidding in the organization for 3 years, my lord, without issuing any so-called notice, my lord. My lord, the petitioner was a successful bidder through lottery system, and LO as letter of acceptance was issued under Annexure 4 at page 61, my lord, in which the petitioner was asked to deposit last para. In case you do not deposit ISD and APS within 15 days of issue of this letter, it would be construed that you have not accepted the offer, and the letter thus issued shall stand cancelled before expiry of.
So what is your prayer?
My prayer is to quash the Annexure 5, my lord.
What is that? What is the effect of Annexure 5?
Annexure 5, I have been blacklisted without issuing any so-called notice.
For how many years?
3 years, my lords.
Yes.
Well, in fact, my lord may kindly see page 82.
Notice was given to him or not?
Notice was not given because he has submitted the undertaking that if I will withdraw from the contract, then I will be blacklisted. That document also, page 82, Annexure 13.
So then you will have to issue notice. When then? That is not automatic. File affidavit.
I have filed the
You have
affidavit.
filed, then we will interfere.
That stand you have taken in your counter affidavit.
Yes.
Where is that?
Yes, I'm showing. But that is Annexure 5, it is mentioned.
Annexure 5.
Yes. That is the order of blacklisting, it is mentioned.
Hmm?
In the order of blacklisting, it is mentioned. Page 62. May I please?
Yes.
Sir, with reference to the subject cited above, the letter of award issued in your favor is hereby cancelled as per clause number 2.4 of decision of the tender document, and you are hereby debarred for 3 years from the date of issue of this letter for further bidding in OMC as per bid security declaration submitted in the tender by debtor. So serial number 2, that is annexure 13, page 82, that is the bid security declaration.
Page 32.
82.
82.
Yes, annexure 13.
Annexure
13, 1, 3.
Sure. $82.
Yes, 82. Annexure 13.
Which
That is-
clause?
That is bid security declaration dated 9/11/2021. Towards last bottom B, clause B. No, last paragraph, my lord, we hereby accept. Third paragraph, we hereby accept that we may be disqualified from bidding for any contract with you for a period of 3 years from the date of disqualification as may be notified by you without prejudice to OMC's rights to claim damages or any other legal recourse if, then clause B, we have withdrawn or unilaterally modified, amended, revised our bid during the bid validity period specified in the form of bid or extended period if any.
Yeah, about that particular line, you say that you admit that there no opportunity has been provided to him. That you have stated in your counter in view of this particular
Paragraph 11.
Paragraph 11 of your counter affidavit.
Yes.
Yes, you had
No, my lords.
given an undertaking.
My lords, I have undertaken, but I have not withdrawn my bid security. I have sought permission to permit to back up from the tender process because there is a hike in price when that is pending. And pending for their consider, they have not rejected my application permission letter, my lord. They have unilaterally blacklisted me. And they have blacklisted me under clause.
No, there is no question of unilaterally. You asked them that you please blacklist me.
No, I have not blacklist. I have sought permission. I have not withdrawn myself, my lord. There is no document to show that I have withdrawn from the tender process, my lord. In case I have filed an application for withdrawn from the tender process, then I will be blacklisted. Further, my lord, they have blacklisted under clause 2.5 IV. They have given me 15 days time. and that time was not expiry. After 9 days, 15 days time. Under that clause, if any bidder failed to deposit the ISD and APS within 15 days, he can be blacklisted. But that 15 days time was not over. After 9 or 10, they have issued that letter 7/11/2022 and blacklisted me on 16/11, my lord. That means 8 days, after 7 or 8 days, they have blacklisted me without any show cause, my lord.
No, the first A says that we are in breach of, except that we may be disqualified from bidding if we are in breach of any of the objections under the bid.
Yes, my lords, that is, they have not specified point where who is for clause we have breached, my lord. They have clause 2.115, one what you can set aside.
Yes, we are setting aside the order.
My lord, may kindly see page 61, annexure 4.
No, give him a notice that you are going to blacklist him. You consider his reply and then blacklist him.
Your lordship may pass that order.
This is what we are going to.
Yes. No, only some facts, my lord, I am so. My lord, may kindly say he said that he has not withdrawn from the tender process. My lord, may kindly see page 61, annexure.
No, this you could have done after having considered his so-called notice. Reply. All right.
But admittedly, he has withdrawn from the process.
Maybe, admittedly, he might have committed some crime also. But some decision will have to be taken in accordance with law.
Yes.
In the presented application, the petitioner has put to challenge an order passed by the opposite party number 2. Dated? What is the date? What is the date of order?
Date number 16/12/2021.
21. 16th December 2021.
Which annexure?
16, that is 5 annexure, page number
15/12/2021, whereby the petitioner has been debarred for 3 years from the issue of the said letter for further bidding in OMC. What is OMC?
Odisha Mining Corporation.
In Odisha Mining Corporation, bracketed OMC, as per the bid security declaration submitted in the tender wide NIT number 39/OMC/civil/2021. It is the petitioner's case that before blacklisting the petitioner through the said letter dated 15/12/2021, no so-called notice was issued to him asking him to explain as to why company hai na? Company, why the company should not be debarred / blacklisted. So stop. A counter affidavit has been filed on behalf of the state of Odisha.
Not OMC.
On behalf of OMC, Odisha Municipal Corporation. Mining Corporation, wherein a plea has been taken that the petitioner himself had undertaken that it may be blacklisted in either of the following circumstances. What also page? Which page is that?
Page 82 there.
82. Sorry. What? Oh, page 82, ABC. Stop. It has been argued on behalf of the OMC that what did he do according to you?
Yes. A and B. Both
That
applies to the fact of the
the
present.
petitioner withdrew unilaterally. This is
Yes.
your plea, B.
Yes, B.
Withdrew unilaterally the bid during the bid validity period specified in the form of bid, and accordingly the competent authority passed the order of blacklisting / debarring in terms of debarring in consonance with the bid security declaration dated 9/11/2021, bracketed annexure 13. In reply, learned counsel appearing on behalf of the petitioner has submitted that it was in complete breach of principles of natural justice that the OMC, that the opposite party passed the impugned order of debarment / blacklisting without giving the petitioner any opportunity of hearing. First off, had any so-called notice been issued to the petitioner would have justified his action / inaction. Justified means explained. First off, next. After having gone through the pleadings on record and submissions advanced on behalf of the parties, we are satisfied that there has been patent breach of principles of natural justice while passing the impugned order of debarment dated 15/12 16/12/2021. Stop. It is an admitted position that no prior notice was given to the petitioner asking him to explain as to why an order of blacklisting be not passed. Stop. The impugned order, in our opinion, deserves interference, which is accordingly set aside. Stop. We make it clear that the opposite parties shall be at liberty to pass an order afresh after giving the petitioner an opportunity of hearing if the OMC intends to blacklist / debar the petitioner for any period. This application is allowed with the aforementioned observation. Okay.
Item 45.
No one appears. 2 weeks.
Item number 46.
So the case, my lords, I was arguing yesterday. Lordships had asked me to tell the opposite party number 4 to remain present, my lords. Unfortunately, his phone number also is not working, my lords. We have tried. My friend tried a number of times. He did not respond to the phone calls. I mean, it wasn't good. And we have also taken instructions. He's withdrawn.
He's withdrawn his bid.
He has withdrawn his bid from the government, my lords. Well, as I was saying, my lords, there were two packages.
I'll take instruction, my lord, whether he has been withdrawn or not. Lordship can fix it.
Because there were two packages. He did not want to contest for one package. Accordingly, for which I am selected. Accordingly, a lottery was held excluding him. And I was selected. Now, my lords, after my selection, the tendering authority recommends my name, but the chief engineer says, no, give it to him. Without application of mind, my lords. When he is not even a participant in the lottery process. So that could not be done. So, and he himself has withdrawn the bid on at Annex 6, running page 79.
No, well, my lord, in fact, my lord, chief engineer invited two bids. One bid relates to Ghosar to Angopada, my lord. I have prepared the dead chat, my lord. Let's see, it will be easier. Let's see, 10/10/2022, Chief Construction Engineer, Rural Work Circle, Onugul, opposite part number 3, invited applications from the interested person for improvement of road from Ghosar to Angopada via Kandivahal Road, wherein the approximate estimated cost was fixed at rupees 602.46 lakhs. Similarly, the said notice was also issued for improvement of road from Bagadia to Similpal Road, wherein the approximate cost was fixed at rupees 563.94 lakhs. The last date for submission of both the bids were fixed to 2/11/2022 up to 1 p.m. and date of opening of technical.
Who is Manas Ranjan Rao?
Manas Ranjan Rao is the opposite party 3 my lord. 4 my lord.
Opposite party number 4.
4 my lord, and he was selected in both the bids, my lord. Lordship, fact is like this, my lord. In both the bids, my lord, all the bidders are quoted 14.99 less, my lord. So hence the lottery was conducted. In both the lottery, Manas Rao was successful bidder, my lord. But his bid capacity is confined to one bid capacity. That's why the chief engineer construction, my lord, requested him to take the first work, my lord, because this is a high rate value, my lord. But on the other hand, Manas Ranjan denied that he will not take the first work, my lord. He interested to second work, that is related to Bagadia to Similpal, my lord. Bagadia to Similpal, my lord. My lord. He was selected in both, my lord, in a lottery, but his bid capacity is less, my lord, with regard to two works, my lord.
So this dispute is in relation to which work? Both the works are.
Bagadia to Similpal, my lord.
No. This relates to Ghosar to Angapada Road.
Ghosar to
Angapada, my lord.
Angapada.
Who was the L2 bidder?
There are no L2
There is no L2 bidder, my lord. Subsequently, my lord, what happened, my lord?
14.99.
I am submitting, my lord. 14.99, all the bidders are quoted same rate.
Right.
That's why there was a lottery.
Right.
In both the lottery, Manas Rao, opposite partner 4 was selected. But his capacity is not available to the two bid, my lord. That's why the chief engineer directed him to take the first work, my lord. That is the Ghosar to Angopada, which is highest rate, my lord. But he refused to take this work and he requested to give him another work, that is less work. And accordingly, my lord, the chief engineer recommended the case for the next authority, my lord, chief engineer. And while the matter stood thus, my lord, chief engineer conducted the second lottery. And in that second lottery, my lord and senior friend, is the highest bidder, is the successful bidder, my lord. And in the meanwhile, what happened, my lord? The technical committee rejected the recommendation of the chief engineer, chief construction engineer, stating that he has to give the first one, my lord.
He has to give.
He has to give the first work because this is the highest rate, my lord. This is the position. And being the rejection,
Manas has to be given the first one.
Manas on first.
My lord,
Being the
there was-
rejection, my lord, senior friend has filed the.
My lord, Annexure 7, once he refused to take up this work, Annexure 7, a subsequent lottery was held, my lords, excluding him. So he has gone out of the fray. Annexure 7 at running page 80.
In the second lottery, he did not participate.
He did not participate because he backed out. By Annexure 6, he backed out. Annexure 7 was held after he backed out. And he was excluded. It is, if your lordship takes up running page 80, to clarify, your lordships may see Annexure 4. Annexure 4, page 74. Your lordships may see 5 bidders were invited. R.N. Agarwal, Lakshman Pradhan, Prasant Kumar Samantray, Saroj Kumar Raul, and Manas Ranjan Raut. My lord, Saroj Kumar Raul is the present petitioner. 5 bidders were called for, my lords, by Annexure 4, as they all had quoted 14.99% less. As I was apprising your lordships on the yesterday, that if you quote 15%, your bid is liable to be rejected. So, my lords, what happens? Now, by Annexure 6 at running page 79, he says, I don't want to take up this work, improvement to Ghosat to Angapada Road. And because he had not disclosed his bid capacity, which was not enough for both the works, he said, I will take up the other work, I will not take up this work. Now, once he does this, again a subsequent lottery is held by Annexure 7, where if your lordships may kindly
For the bigger work.
My lord?
Lottery only for the bigger work.
For the bigger
one.
For the
Yes.
bigger one.
Now, your lordships may kindly see this. Here, my lords, only 4 participants. Raghunath Agarwal, Lakshman Pradhan, Prashant Kumar Samantray, Saroj Kumar Rao, the present petitioner. Manas Ranjan Raut was excluded because he went out of the fray. If he goes out of the fray, then, my lords, I emerge successful in this lottery. Was recommended by Annexure 8, it was recommended. Your lordship sees running page 81. They say the winner of lottery and first lowest bid at 14.99% less than the estimated cost of 6 crores and such of Shri Saroj Kumar Raul, A-class contractor amounting to rupees 5 crore 12 lakhs, only is hereby recommended for approval. And by Annexure 9, my document verification takes place. Everything is found to be correct. By Annexure 10, they recommend my case. And certainly, my lords, Annexure 11, my lords, without recording all these facts, my lords, suddenly they said, no, this work should be allotted to him. And he doesn't even, my lords, he himself has withdrawn. He's not participated in the lottery. How can the work, nor is he participating here, my lords, before your lordships, which shows his total disinterest in this work. How can you force this work upon someone, my lords, while I, who am willing to execute this work?
That they may not force, but where is your right?
My right, my lords, I have emerged successful in the bid itself.
So his technical bid was not.
My technical bid has been approved. That is why my financial bid.
Approved, my lord. Financial bid has also opened, my lord. All the bidders are quoted 14.99%. That's why there are lottery, my lord. And in both the lottery, Manas Rao, the opposite partner, succeeded and became the successful bidder. But his bid capacity, because his bid capacity does not tally with the two bid.
No, that is not the question. The question is that all of them had quoted below 15, 14.99. All right. Now you decided to draw lottery. You did that. And in that, he was successful for both the bids. Now you decided you decided to give him the bigger work. He declined. You gave him the smaller one. You gave him. Then for the first bigger one, you had to take a fresh decision. And therefore again you had to draw lottery. You do lottery. But you do lottery from amongst 4 persons only. He was excluded.
My lord.
So how can you award now the work to him?
My lord, at that stage, my lord, the chief construction engineer recommended both the names.
No, man.
Initially had recommended the name of the Manas Ranjan Rao
No.
with regard to smaller one.
No, man.
Thereafter, the second time lottery was conducted.
Right, after
Second lottery was conducted for what?
Because the chief construction engineer had
One work or both the works?
my lord.
One work.
So if the work was conducted only for, if the lottery was drawn for only one work,
My lord.
in which the this
Manas Raut.
Manas did not participate,
My lord.
then how could you award the work in his favor?
Because the committee, my lord, at that moment, my
In
lord,
any case, we will have to issue notice.
Notice is issued.
notice was issued.
He's not appealing in spite of his name.
His name is appearing. Man.
In
In the past, he has appeared.
Lordship, he's challenging the award to the Manas Raut, my lord, opposite partner by vote
What
to be.
benefit you will get? That person is not interested.
My lord.
How can you impose him to do that work?
No,
Man is
my lord, we are not imposing, my lord, by virtue of a proceeding, my lord, of the committee, my lord, at page 116 of the writ petition, I have filed in counter affidavit. In that writ petition, my lord, committee said, because as per the procedure, you have to give the highest work, the amount of the work to the first person.
It's all right, but he is not.
My lord, maybe, my lord, then your lordship may dispose of.
That is why
Yes,
the
my
second
lord, my
lottery was held.
My lord, my lord. If he is not interested, my lord, that's why.
Annexure 8, page number 81.
My lord, that's why, my lord,
Successful man.
I want to take instruction, my lord, whether he has to withdrawn that bid or not. That's why my lord senior submitted.
Monday we will dispose it.
My lord.
Monday you
My
come
lord,
with
my lord.
instruction. We will
My lord, my lord.
Obliged. Senior counsel appearing on behalf of the petitioner and counsel representing the department representing state of Orissa. Stop. This matter on Monday for final disposal. Stop. Run counsel appearing on behalf of the state shall be required to inform this court as to whether the opposite party member
4 mile.
4 has withdrawn himself from the bidding process.
Mile.
In connection with what?
Gosar to
That particular
Angapada
work may be.
In connection with Ghosal
to Angapada Road.
construction of road from Ghosar to
Angapada
via Kadinga Bahal. Kading Bahal Road.
Obliged. Interim order may cut.
Interim order shall continue. What is the interim order in this case?
The work, well, award of the work has been stayed. Annexure.
Item 47.
Right, please, Your Lordship. Yes. Your Lordship looks at actually this is regarding a plot of land earmarked to be allotted in favor of the petitioner to establish a 5-star hotel. After Bhubaneswar became a smart city, actually they invited a lot of applications. But if Your Lordship looks at the order dated 19/4/2023, 19/4, the matter was taken up for admission.
Yes.
And OP number 3 was directed to appear, notice was issued. But I found in the noting, somebody has appeared, Mr. Mahanti has appeared for OP number.
Yes, my lord. On behalf of Mr. Senior Counsel, Mr. Mahanti, I am appearing for the OP number 3, my lord.
You are for?
OP number 3.
my lord. I pray for 3 weeks time to file counter. I have already received the parawage from April.
Because single window committee recommended the land to be allotted in favor of the petitioner. As per the government policy, government gives the land to IDCO. IDCO is the industrial concern who allots the land to the industrial sectors. So that has been given to them. Already IDCO has got the land, but he is not giving it to the party.
What right do you have?
Sir, right is actually the government themselves recommended my name for the purpose of allotment.
And what is the policy of allotment?
Sir, IPR policy is that the government wants that to set up hotels in the periphery of Bhubaneswar and Bhubaneswar city itself for the purpose of industrial growth as well as for the tourist attraction. And a lot of people have been given, allotted. Only he has been singled out, he has not been given. And the land has been transferred in his favor to allot it in my favor. Land has been transferred by government, earmarked for the petitioner's hotel purpose. I've invested huge amount of money for that purpose in this.
Yes, so is for the IDCO.
I am for IDCO, my lord.
He wants time to file counter.
How much time?
Yes, 3 weeks time, ma'am.
One year was not enough for you. By way of last indulgence, 3 weeks time is allowed to IDCO to file counter affidavit. This goes on 4 weeks. Time in the meanwhile may be utilized by the petitioner to file a rejoinder if so required.
Right. So that's an interim order on that date. Paragraph 5, if you look at in that order.
The interim order dated 19/4/2023 passed in this case shall continue in the meanwhile.
Grateful.
Item 48.
My lord, in this case, my lord, the petitioner is appearing for the interest of the village Koprikocha, and it is a public interest litigation for the interest of the villagers are concerned. And villagers are belonging to 70 to 80% villagers are scheduled tribe persons, and it is near about 400 kilometers from away from the Bhubaneswar. And the villagers, the lands of the villagers are acquired, and the Gram Sabha was constituted, and land was allotted to the villagers for their resettlement. But in the Gram Sabha was held in 2010, and the land which was allotted for the residential purpose of the ousting, that land was not given. And over that land, the villagers also constructed some houses in the allotted over the allotted land. And Tahsildar said that the land is not fit for homestead. He has written a letter that it is not fit for homestead, and over that land, the overburden dump by the overburden dump, OBDUM, has been created by the NTPC.
What is that?
Overburden dump, my industrial coal, the waste coals and other waste materials of the were gathered over the homestead land of the villagers. For that reason, my lord, a committee was formed to fight out their right to get the adequate compensation and to get that land. and to clear the overburden over the land allotted for the RR policy. But till today, no compensation has been paid and no land has been allotted to them. For that reason, I have approached before this Honorable Court earlier, and in page 57, kindly have a glance. In page 57, your Lordship directed that the collector will take a decision over the matter about
You filed
the
affidavit.
affidavit that filed.
I have already filed an affidavit. The Lordship may kindly come to the prayer. But here the state government had issued a notification for acquisition of land for NTPC for extraction of coal millers, more than 121 acres of land. Accordingly, notification was made. Payment was compensation was also given to the millers, all land of whose land was acquired millers. And thereafter, RR benefits, that resettlement benefit under 2006 rules was also given. And a certain plot was identified for their settlement millers. Now they say that give us a different area or remove the OB millers dump. OB dump is mandatory millers. It within this millers now that after the time of excavation of millers coal, the materials which are collected millers and by the junks millers, it will be deposited there only millers. So now they want that you remove that OB dump yard from the millers area which has been earmarked for that millers.
So whether they are justified or not.
No, because they have been given millers adequate land for resettlement millers. I have given a counter affidavit to Lordship may kindly.
Whether that is a proper situation for them to live.
Yes, millers. Houses have been constructed by some of them. Some of them not.
Because of this OB dump. The OB dump, whether it is healthy for them to live.
It's not the area which has been earmarked for the living millers away from that OB dump millers. We have stated that also in our counter affidavit millers.
Yes.
But if your Lordships have filed a counter affidavit to which my friend has not responded, that affidavit was filed on 13th of 11/2023 millers.
Yes.
At page 6, paragraph 10 millers. I've given the details millers.
Yes.
That the total numbers of family displaced in the village Khapur Kachar comes to 161, out of which 52 are PDF mills, partially affected families have been shifted to RR colony constructed at village Kalamega, and 41 PDFs opted to self relocation and 15 opted for shifting to said RR colony. Out of the remaining 54 millers, 6 people are dead and 29 PDFs opted for shifting to Modokondam, that is adjacent to this village. The proposed new RR colony. It is pertinent to mention that a Gram Sabha meeting was conducted on 16/2022 in Kapurpura village under the chairmanship of ADM Sundargarh in presence of the villagers of Sarpanch, Sanmugara GP, BDO, LAO and IAC and ward members of that Gram Panchayat, the NTPC, Dalunga officials, wherein it was decided that allotment of house site plots at Modokhaman is provided under the RR policy to be provided for shifting of remaining 48 out of this. So now they've been, it has been decided to shift them.
It has been decided to shift them.
Yes.
Is it?
So in spite of that, they are objecting that they've been
No, where have you stated that they have decided to shift?
On their objection, now it has been decided to shift.
Where is that?
That is stated,
Huh?
Page 7, where I have stated that the IACM Grimers are around 6 lines below millers. After that, LAO Hemgiri, IAC Hemgiri, PS ward members.
6
1 second.
Yes, from the beginning I am stating that.
Page 56 where?
It is pertinent to mention here, second line, that a Gram Sabha meeting was conducted on 16/11/2022 in Khapur Kachar village under the chairmanship of ADM Sundargarh in presence of Khapur Kachar villager, Sarpanch, Sanmuga, Gram Panchayat, BDO Hemgiri, LAO Hemgiri, IAC Hemgiri, PS ward members of Khapur Kachar and NTPC Dulanga officials, wherein it was decided that allotment of house site plots at Modokhamon is provided under R&R policy to be provided for shifting of remaining 48 PDFs, out of which 29 PDFs have already opted to Modokuma and the new RR colony on this issue of a new site, namely Modokuma adjacent to village, Kapur Kachar village. The general manager Dalunga coal mining project NTPC has now filed a requisition seeking lease of government land measuring 10 acres out of government non-forest land for the aforesaid area and adjacent for construction, establishment new RR colony for shifting or remaining PDF. So, Millers, we have now decided to shift them to this new area, Millers, and the OB dump has to be there, Millers. Now I will obtain instruction on the basis of which the 10 acres, once it is granted, Millers, they can also be accommodated there because it's RR policy, Millers. Now they have to given, they cannot claim as a matter of right that this place should be given to us, Millers.
My lord, but whether the question is of public interest.
Right, Millers.
The question is of suitability of the place where they are being settled under some rehabilitation scheme.
Right, Millers.
So suppose you rehabilitate people by settling them to a particular place, and because of subsequent development, it becomes impossible for them to live.
Yes. Not congenial, Millers. Then that is why 10 acres land has been recommended to be allotted by the government to the NTPC for construction of a new R&R colony, Millers.
My lord, till today they have not decided to.
Till then?
In the Gram Sabha.
So you file a reply to this.
My lord, in Gram Sabha they have held on 2010 and the Gram Sabha was called by the ADM, which is not correct, my lord. Gram Sabha will be conducted
in the counter affidavit.
Yes,
the latest development he has stated in that page number 66.
Yes.
So, what we want that, why don't you file your rejoinder to this appeal? If you are disputing any of such things, he said that 10 acres land have already been
allotted, but they have not given a compensation amount is not given. And over the dwelling house, there
kindly come to the prayer. There are no whisper of compensation.
Compensation amount, he said that it has already been
not paid. They have admitted in the counter. Kindly have a glance.
See your prayer.
My lord,
also kindly look at this prayer itself.
In my lord, kindly have a glance.
There is nothing that compensation has not been paid.
Not been paid. Compensation
Page
has not been
19,
released.
prayer, Millers, page 19. Therefore, the prayer that Honorable Court may graciously please to admit this PIL, issue rule calling upon the operator so called to destroy OB dump shall not be removed from the allotted land and the land outreach of Kapurpura R&R colony in the alternative till final decision taken by the OP number 2 over the representation to implement R&R policy. The OP number 5 till then be restrained to the industrial waste and coal dumping thereby. This is the prayer.
Obidum. They do not create obidum over our dwelling nearby the area for the
Why are
dwelling
you
house.
introducing this plea of payment of compensation?
Not released, my lord.
Huh?
Not released. Kindly have a glance to pay para 5 of the counter. In para 5 of the counter, kindly have a glance. In para 5. In para 5, they have stated that it is submitted that the obidum area is selected.
Forget their counter affidavit.
In counter, they have stated that they have not disbursed the amount over the for the RR policy, and they have not also demarcated the land in lieu of the Kaprikacha village, which was earlier allotted to us.
So where are we living now?
Now we are living in our residential area at Kaprikacha, and they have not given any compensation and not given the land in lieu of that residential
Where
building.
is the provision for compensation?
Under the RR policy, they have to give the all compensation and implement the RR policy. They have also stated that in view of the new RR policy, they will have to deal with
from the RR policy.
right to fair compensation and transparency in land acquisition and rehabilitation and resettlement act 2013.
Now you are coming to act.
Act over
Before there is
kindly
no
have a
other-
glance and special care should be taken to for the scheduled caste and scheduled tribe. They have not also taken. In kindly have a glance. 41 of the error policy.
You see that counter
41.
affidavit, paragraph number 5.
Yes. 5, my lord.
Page number 63. See that they have stated that the land compensation amount as well as amount for structure valuation have already been disbursed to the land. So where you find
Not
they have
disbursed, my
admitted
lord,
in their
they have-
counter affidavit that they have not.
My lord, page 59, kindly have a glance. 59.
Why are you not reading paragraph 5?
Paragraph 5, my lord.
5.
Paragraph 5 of the counter,
Yes.
it is submitted that the Obidum area selected and earmarked already approved by in the mining plan over which the dwelling house are constructed by the villagers have already been acquired under the project of Delunga Coal Mines project of the NTPC Limited, wherein the land compensation amount as well as the amount of structure valuation have been already been disbursed to the land entity except the structure of 18 project displaced family. But not 18, not 18, 33 families are residing.
You are not filing any rejoinder affidavit.
My lord,
That is why it was.
it is a public interest litigation. For that reason, my lord, without going
You
to
are
the
now
process.
taking a new plea about non-payment of the compensation that has not been taken in the
Not-
petition. Rather,
they
in
have
the
not.
counter, it has been stated.
While you are rejoinder, we are not against them. We shortly will come.
My lord, the whole difficulty is that they are creating obidum over our dwelling house. That may be stayed for that reason.
No, they say that some alternative arrangements shall be made for you.
Arrangement has been made, but not implemented. They have, in the official level, they may have taken any decision without consulting to the villagers.
Be clear in your submission. Whether you want.
Without consulting the villagers, they have not taken a decision to where they will reallocate the land where the forest dweller, the tribal people will resides. Rehabilitate.
They have mentioned in that place name has also been mentioned. That
Well.
10-acre land. Please come to that.
10 acres, yes.
Paragraph now, page
They
number
have-
66. Mentioned where they will give you those, construct those houses. Not only 10 acres.
See, Mr. Council, we are making it clear that we are showing this patience because they are serial tribes.
Yes.
All right. Therefore, we are trying to find out some solution if they are in real trouble. If you just want to waste the court's time referring to your pleadings in the writ petition and what is there, it's a different matter. There is some statement in the counter affidavit. If you want to controvert that, you do that. If you can't do, we shall do. We shall depute someone to inspect what is the best in the welfare of the scheduled tribes. But you will not do anything.
No,
wonderful. We will do. You disengage yourself from this proceeding. We will engage someone else. Because this matter relates to rehabilitation of scheduled tribes.
Yes.
These matters cannot be taken up so lightly.
I will file a rejoinder, my lord.
If you want to, if you can do, if you want to do, if you can do, please do. If you can't, and if you don't want, we shall do. Yes, we have agencies.
I will file a rejoinder.
We do have agencies.
Till then stay, maybe not to create an obidum over the residential building.
File your specific affidavit if you want.
A stay petition is there. For interim relief, I may be interim protection may be given. interim protection may
No
be
interim
given.
protection.
My lord,
List this matter on 2 weeks. Stop. The court is not satisfied with the manner in which the matter has been conducted on behalf of the petitioners by not duly addressing on behalf of the tribals, by not duly addressing the averments made in the counter affidavit filed on behalf of the state of Odisha. State of Odisha?
Yes, please.
State of Odisha. So stop. If on the next date, the court does not find any appropriate pleading dealing with the counter affidavit filed on behalf of the estate, the court will consider passing appropriate orders in the best interest of the tribals of the area.
my lord, as regard to interim relief, I have mistakes.
You do whatever you want.
My lord, interim order may be, protection may be given that over our nearby the area of the dwelling house, they will not create any obidum.
This,
my lord,
this writ petition was filed in 2023. We are in 2024.
my
You
lord,
will see that in heaven will not fall
due to
into
pendency of the case, they have not, they are not
yes.
throwing any obidums, creating an obidum, my lord. If they will create obidum over the area where we have not been displaced, we are residing in the dwelling house, and nearby area is covered by the obidum. Obidum may be further obidum not be created. They will not create any obidum further, my lord, till this interim relief may be granted.
Item 49, next item, that batch of case matters, item 49. I was wondering if it could be taken up next week.
What is this matter about?
That mining matter that revised demand.
All right, 49 years.
40.
49 to
Next. Tomorrow, day after, I'm a little inconveniently placed.
list this matter, list these matters on 1 week.
Merits. Interims to continue, interim arrangement.
Also self-contained.
Grateful.
I beg pardon, my lords. Item 59, lordship, the entry model is expiring today, my lord.
59.
My lords. State has not filed any counter in the matter, and the entry model is expiring today, my lords.
Grant some time, my lord, we'll file counter affidavit within 2 weeks.
59. 2 weeks time is allowed for the further time is allowed for the state to file counter affidavit. The interim orders shall continue in the meanwhile.
51, can we have it next week, my lords? Pleadings are complete.
Let it come. Tomorrow it will be there.
Tomorrow, day after, I am a little,
All right, 51.
next week, pleadings are complete.
51.
Grateful.
Your lordship, item
No
50,
further-
2 weeks time may be granted to file additional affidavit.
Let it come tomorrow.
45, my lord, or next week? 45.